Can I ask the correction officer to move the mic away from him, the one on the podium? Thank you.
All right. Good morning, sir. Please tell me your name.
Carlos Rodriguez.
Mr. Rodriguez, this is case number
Señor
20
Rodriguez,
CF.
esto es el caso 20 CF.
Madam Interpreter, do you want to remote into the court?
Yeah, I'm so sorry, Your Honor. I didn't
That's
realize
okay.
my foot was on the pedal.
That's okay, no problem. Again, this is case number 20 CF 8225. Sir, you were
I'm
arrested
sorry,
for
Your Honor.
trafficking.
Could I just ask? I'm sorry, Your Honor. Could I ask you to get closer to the mic? You sound far away.
No, can you hear me?
Yes, Your Honor.
Better? Okay. Mr. Rodriguez, you were arrested for trafficking in heroin greater than 4 grams, but less than 14 grams, possession of a firearm in the commission of a felony, possession of drug paraphernalia, and possession of heroin with intent to sell with a weapon. There is probable cause. I will appoint the public defender to represent you. You are not to possess or consume any controlled substances without a valid prescription. You are not to possess any weapons or firearms. Bond on count 1 is $25,000. Bond on count 2 is $150. Bond on count 3 is $100. Bond on count 4 is $150. I'm also going to place you on pretrial release and have you submit to random urinalysis testing, sir. Thank you. This is Spanish too, right? Hector,
Yes. What's the name on it?
Hector Roman Diaz?
Yes.
Okay. Sir, good morning. Tell me your name, please.
Hector Lugo Sandoval.
Luis Roman Diaz.
Roman Diaz.
Thank you. Sir, this is 20 CF 8210. You are arrested for robbery armed with a weapon. There's probable cause. I'm going to appoint the public defender to represent you. You are not to return to the Wawa. You are not to possess any weapons or firearms or have any contact with the victim. Your bond is going to be $2,500. I am revoking the bond in 20 MM 4799. That's going to be set at none, sir. Thank you. Madam Interpreter, that is all the cases that we have this morning.
Yes, thank you, Your Honor. I will disconnect.
Thank you. Have a great day. Just set the grill to the side. They're just
Yes.
going to call in. Okay. Oh, wait, this reset is Spanish. Yeah.
We have another Spanish.
Yeah, I just saw that.
Medical.
Oh, he's not coming. Julio Castro Phoebus.
It's medical.
Thank you. All right. Ms. Cusson, it looks like your office was previously appointed. Did you want to waive his appearance again?
Yes, Your Honor. I was just asking if his bond could be reduced. We have reset it to take testimony for him, and he's in medical, so I don't foresee him coming anytime soon with what that means. So at this point, I still am requesting him be ROR because it's a possession of heroin charge, and I don't need it to be reset.
Okay. Ms. Fusco, did you want to be heard at all?
We just asked to stay the bond.
Okay. So I've reviewed the arrest affidavit. I've also reviewed his first appearance information sheet. And I'm going to release Mr. Castro Phoebus on his own recognizance at this time. He's not to possess or consume any controlled substances without a valid prescription. Are you Mr. Higgerson?
He's the Creole interpreter, Your Honor.
Oh, this is Mr. Guzman?
Yes.
So, Mr. Guzman, the interpreter is not ready yet, so I'm going to have you have a seat, and we'll call your case as soon as we have the interpreter. Good morning.
Good morning.
Sir, tell me your name, please.
Andre Higgerson.
Mr. Higgerson, this is case number. Mrs. Wood, did you want to approach? Did you provide a copy of that to the defense?
Yes, Your Honor.
All right. Do you have any issues with the probable cause?
No, Your Honor.
Okay. Mr. Higgerson, you were arrested in 20 CF 8183, as well as 20 CF 8182, for tampering with a witness to hinder communication to law enforcement, battery, dating violence, battery on a law enforcement officer, injuring or killing a police dog, and possession of cocaine. There is probable cause, sir. I'm going to appoint the public defender to represent you. I don't see a witness for Mr. Higgerson. Was testimony taken yesterday? No. Okay. Mr. Higgerson, you are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. I'm going to place you on pretrial release at this time.
Okay.
Sir, do you have any questions about anything that I've ordered?
No, ma'am.
Pardon me, sir?
No, ma'am.
Okay. Thank you. Good morning. Your name?
Carl Shepard.
Mr. Shepard, I'm not quite sure why you're here this morning. Okay. Mr. Higgerson, or I'm sorry, Mr. Shepard, I'm just informing you that, sir, when you are released from the jail, you have reporting requirements.
Okay.
All right, sir, thank you.
Your Honor, was this as to both cases? There were two sets?
For Higgerson.
What about it?
For Higgerson, there were two cases. You released each here on both.
Correct.
Smith was medical.
Okay. Is there a witness here for Mr. Smith? All right. Ms. Custon, I'm going to appoint your office to represent him. Would you like to waive his appearance?
Yes, Your Honor, the lead is out on bond. He has a private, and that's why it was reset, but he has defenders.
Okay. All right, I'll appoint the public defender in 20 CF 8155. He was arrested for grand theft of a motor vehicle and possession of a controlled substance, as well as 20 CT 4173, attaching tag not assigned, and there is 20 CT 4172. I didn't see any probable cause establishing the driving while license suspended or the attaching tag not assigned in any of the affidavits. Can anyone point me to where that information is? And I don't have a ticket either, unless, I don't see it here at all. The affidavit appears to me to be the same for each case.
I just see, Your Honor, that he ran the plate, and the plate was on a Dodge Charger, but it was, the plate that was attached to the vehicle came back as a Toyota, so it was the incorrect plate.
You just check this box, the supplemental report. Put another. Forget.
All right, well, on the 20 CF 8155, there is probable cause for both of those offenses. Bond on count 1 is $2,500, bond on count 2 is $150. I don't find probable cause in 20 CT 4173 or 20 CT 4172. He'll be released ROR on those. I'm revoking the bond on the out on bond case. That case is set for a pretrial conference in September, so I'm going to set that bond at none. Sir, good morning. Your name?
Allen.
Mr. Allen, sir, you are here in 20 CF 8212. You were arrested for aggravated assault, domestic violence. There's probable cause. I will appoint the public defender to represent you. Is there a witness for Mr. Allen?
No, Your Honor.
Mr. Allen, you're not to have any contact with the victim. You're to maintain a separate residence. You are not to possess any weapons or firearms, sir. And your bond is $2,500. Do you have any questions, Mr. Allen, about anything that I've ordered?
Nope.
Mr. Allen? Sir, did you have any questions about anything that I ordered?
I said no.
I didn't hear you, sir. Thank you.
Hello.
Hello, good morning. Are you Mr. Davis?
Yes.
Mr. Davis, you're here in 20 CF 8223. You were arrested for tampering with a witness to hinder communication to law enforcement, battery, domestic violence, and assault, domestic violence. There is probable cause for the offenses. I will appoint the public defender to represent you. Is there a witness for Mr. Davis?
No, Your Honor.
Mr. Davis, you are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or any firearms, sir. Your bond on count 1 will be $1,000. Bond on count 2, $100. Bond on count 3, $100.
Your Honor, as for tampering, we argue there's no probable cause, that my client did not take the phone in order because he knew that she was going to call the police. There's no indication that there was any suggestion she was going to be doing that. So we argue that there's no probable cause. We have to do our work.
Ms. Wisco?
We do argue that it says in the third paragraph down, rating stated Davis hit her phone, so she couldn't call the police.
I do find that there is probable cause. Bonds will be stated as previously stated. Sir, did you have any questions about anything that I ordered?
No, thank you.
All right, thank you, sir. Good morning. Tell me your name, please.
Johnny Toussaint.
Mr. Toussaint, you are here in case number 20 CF 8224. You were arrested for robbery, sudden snatching, tampering with a witness to hinder communication to law enforcement, and battery, dating violence. Is there a witness for Mr. Toussaint? Mr. Toussaint, you are not to have any contact with the victim. You are to maintain a separate residence. You're not to possess any weapons or firearms. Courtney, does he qualify for free trial?
I'd like to
What?
have the opportunity to speak with her if possible. Am I allowed to talk to her?
But on 2 and 3? Okay. So, Mr. Toussaint, I'm going to ROR you on count 1. Counts 2 and counts 3, you'll be placed on pretrial release, sir.
Your Honor, can we readdress Davis?
Yes, after we finish with this case.
Sorry.
That's okay. Mr. Toussaint, do you have any questions about anything that I've ordered?
I have a question about paragraph 3,
Okay.
where it says, once in the parking lot, Dallas exited her vehicle and started walking after Toussaint.
Mr. Toussaint, listen, Listen, those are questions that you're going to want to talk to your lawyer about. I'm not saying anything in the police report is true or false. This is just what they've given me, and I'm telling you what you were arrested for. Anything that you want to dispute in the police report, you'll need to talk to your lawyer about.
Okay, I understand. Thank you.
All right, sir. Sure. Any other questions, though, about the no contact order?
No, it's pretty clear.
All right. Thank you, sir. All right. And you wanted to revisit Davis?
I'm sorry, the PCR sheet shows he qualifies for pretrial release. I'm not sure if that changes your bond.
All right, thank you.
Mine did
Mine
was there an
says no.
updated one
It was okay, he does qualify for PCR.
on Mr. Davis?
Yes.
Okay. Can I see his paperwork again? It didn't have that on mine, Miss Custon.
One second.
Oh, I'll place Mr. Davis on pretrial release. You're welcome.
Just cross through and initial.
All right. Are you Mr. Burns?
Yes.
Mr. Burns, sir, you are here in case number 20MM167. You were arrested for battery. There is probable cause. I will appoint the public defender to represent you. Is there a witness for Mr. Burns? No, ma'am. Mr. Burns, you are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or any firearms. Does Mr. Burns qualify for pretrial?
Yes.
All right. Mr. Burns, I'm going to place you on pretrial release at this time. Sir, do you have any questions about anything that I've ordered?
No.
All right. Thank you, sir. Ma'am, good morning. Your name?
Hi, my name is Ramisha Caesar.
Miss Caesar, you're here in 20MM4924. You were arrested for battery domestic violence. There's probable cause. I'm going to appoint the public defender to represent you. Good morning, ma'am.
Morning.
Please tell me your name.
Brooke Morgan.
Miss Morgan, do you want to have contact with Miss Caesar?
Yes, I do.
Are you afraid of her?
No.
Do you live together?
We did, yeah.
You did or you do?
We did.
Okay, so you separated now?
Yeah.
Okay. Do you have any concerns about your safety if I were to allow contact between the two of you?
No, I'm not.
All right. Miss Fusco, did you have any questions for the witness?
How long have you known her?
For about 4 months.
Have there been any episodes of violence between you in the past?
It just recently, that's it.
What do you mean just recently?
About a week ago. But I'm not worried about it. I provoked it at the time.
Could you call 911 if something happened?
Yes, I can.
Nothing further, Your Honor.
Miss Custon, any questions?
Yes, Ms. Morgan, does Ms. Caesar get mail to the address that you guys live at together?
That's her house.
Okay, so you won't be staying there if you're not have to maintain separate residence?
I will maintain her a different residence.
Okay. But she does get mail at that address?
Yes.
Would you be worried about her coming to future court dates? She would show up whenever she was told to come?
Yes.
No further questions, Your Honor. We request RR.
At this time, I'm going to order, ma'am, that you're not to have any hostile contact with Miss Morgan. Do you understand what that means?
Yes, ma'am.
You are not to possess any weapons or firearms, and I'm going to place you on pretrial release.
Yes, thank you, Jesus.
Do you have any questions about anything that I've ordered?
No, ma'am.
All right, thank you.
Thank you.
Ma'am, good morning. Your name?
Diane Dawa Lopez.
Ma'am, you are here in case number 20MM4911. You were arrested for battery domestic violence. There's probable cause. I'm going to appoint the public defender to represent you. Is there a witness for Ms. Dowell Lopez? Ma'am, you are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or any firearms. I'm going to place you on pretrial release at this time. Did you have any questions about the no contact order?
No, ma'am.
All right. Thank you.
Thank you. Thank you.
Good morning, sir.
Good morning.
Tell me your name.
John Freeman.
Mr. Freeman, this is 20MM4927. You were arrested for battery domestic violence. There's probable cause. I'm going to appoint the public defender to represent you. Ma'am, good morning.
Good morning.
Tell me your name, please.
Sierra.
Are you Miss Finley? Yes?
Yes.
All right. Miss Finley, do you want to have contact with Mr. Freeman?
No.
No? Okay. Thank you, ma'am. Mr. Freeman, you are not to have any contact with Miss Finley. You're to maintain a separate residence. You are not to possess any weapons or firearms. I am also going to place you on pretrial release at this time. Mr. Freeman, did you have any questions about anything that I've ordered?
No. No, ma'am.
Miss Finley, any questions? No. No? Okay. Thank you, ma'am.
Good morning.
Good morning, sir. Tell me your name, please.
Yamal Hernandez, ma'am.
Mr. Hernandez, you have two cases this morning. You have 20MM4928. You were arrested for battery domestic violence.
Yes, Your Honor.
There's probable cause. I'm going to appoint the public defender to represent you. Is there a witness for Mr. Hernandez? Mr. Hernandez, you are to not have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or any firearms, sir.
Yes, ma'am.
I'm going to place you on pretrial release at this time. And you also have a child support writ, which I'll release you on your own recognizance in that matter. Your court date is August 13th at 3 p.m. There's going to be instructions that you're going to receive on how to phone in for that hearing.
Yes, ma'am.
If you fail to phone in for that hearing, a warrant will be issued for your arrest.
Okay.
Do you have any questions, Mr. Hernandez?
Can you said August 13th, Your Honor? You got it?
Yes, and you will get that paperwork when you are released. It'll give you the call-in instructions as well.
All right. Thank you, Your Honor.
You're welcome, sir. All right. Ms. Custom, did you want to waive her appearance?
You have an argument for probable cause for her affidavit. I don't even know if I want to make it if no release conditions will be set.
So this is what I read the affidavit and had the same concern or idea. I don't think that there is probable cause. I would, if the state wanted to get, request the 24 hours, I would grant that request. I believe it's just missing and didn't copy over into the narrative.
Yeah.
If you want to waive her appearance, so I was going to place her on pretrial release and waive the PC argument.
Yes.
Okay. That's 20MM4934. Ms. Kakao is represented by the public defender. Her appearance has been waived. I'm going to place her on pretrial release at this time.
No condition.
Oh, yes. I'm also going to impose the standard conditions, though, of the no contact, maintain a separate residence, and not possess any weapons or firearms.
Even though I don't know who the victim is in there, but I get what you're saying.
Okay.
Yana, the one I say this, medical, she does have a victim here.
Oh,
Which one? The last one we just
I
did?
think so. Miss, not this one. This is the child support one. For Miss Jessica Kakao. Is that right? Oh, okay.
I'm sorry.
That's all right. It's actually helpful. Sir, good morning. Tell me your name, please.
Richard Nolan?
What is it?
Richard Nolan?
Richard Nolan?
Yes.
All right, sir. And what is your relationship to Miss Kakao?
We're dating.
You're dating. Okay. Do you want to have contact with her?
If it could be non-hostile, yes.
Okay. Do you have any concerns about your safety if I were to allow contact between the two of you?
No.
Are you afraid of her in any way?
No.
How long have you been dating Miss Kakao?
About 9 months, 10 months?
How many?
9 or 10 months?
Okay. Ms. Fusco, did you have any questions for the witness?
Have there been previous episodes of violence between you?
No.
Nothing further, Your Honor.
All right. Mr. Tell me your last name again.
It's Nolan?
Nolan. I'm sorry. It's just hard to hear. Mr. Nolan, if you had any concerns about your safety in the future, would you call the police to report that?
Absolutely.
All right, sir. At this time, I'm going to order that Ms. Kakao not to have any hostile contact with you, and she's not to possess any weapons or firearms.
Your Honor, I do have a question.
Sure.
She does have a dog, and she lives by herself. And I attempted to go downstairs earlier and try to get her keys, and they said it was either all or nothing with the possessions. But to my knowledge, there's nobody else that has a key to her place, and I don't know how to make sure the dog is being taken care of. So how would I go about making sure that the animal is being...
Well, she's going to be released today.
Okay.
But otherwise, I don't know how they can give you her possessions or not. I don't have an answer for that. You don't have a key to her place?
No.
No.
She would have to fill out a property release form in order for him to get the key. But she would have to release all her stuff to him. They just won't release.
Got it. Okay. How would she go about filling out
When I came down, Your Honor, I did request that because that's who I spoke to downstairs,
Okay.
and whoever contacted her, she did deny that. So I just didn't know if there's anybody that could go and take care of the dog.
No, I can't help you with that today, sir, okay?
I understand.
All right, thank you.
Thank you.
Good morning. Are you Miss Lopez?
Yes.
Miss Lopez, you are here in case number 20MM4932. You were arrested for battery, domestic violence. There's probable cause. I'm going to appoint the public defender to represent you. Is there a witness for Miss Lopez? Ma'am, you are not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. I'm going to place you on pretrial release at this time. Do you have any questions about anything that I've ordered?
Is he gonna get hit? Did he get arrested too?
Not that I'm aware of.
Your Honor, I've never been arrested for nothing. Like, this is my first time.
I understand, ma'am. Listen, you'll need to talk to your lawyer about that. I know that you're upset. You're going to be released later today, and you'll be able to make an appointment with your lawyer to talk about the facts in your case. All right? Thank you.
Okay, that's your returning number, okay? Step up.
Ma'am, good morning. Your name?
Adeline Melendez Cruz.
Ma'am, you're here in 20MM4913. You were arrested for battery domestic violence. There's probable cause. I'll appoint the public defender to represent you. Is there a witness for Miss Melendez Cruz? Okay. Ma'am, you're not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms. I'm going to place you on pretrial release at this time. Do you have any questions about anything that I've ordered?
No, ma'am.
Okay. Thank you, ma'am.
I forgot to ask her if I can.
Do you have a question?
Ma'am, yes,
Yes.
does this mean I cannot fly back to Puerto Rico? I have to stay in Florida?
You can go to Puerto Rico. You just have to make sure that you're back here for all of your court dates. If you don't, there'll be a warrant that's issued for your arrest that does reach Puerto Rico. So you'll have to come back. Otherwise, like I said, there'll be a warrant for your arrest.
All right, thank you.
Thank you. Ma'am, good morning. Your name?
Jessica Marie Seacrest Rivera.
Ma'am, this is 20MM 4926. You were arrested for battery domestic violence. There is probable cause. I'm going to appoint the public defender to represent you. Good morning, sir.
Good morning, Your Honor.
Tell me your name, please.
Nelson Azevedo.
Mr. Azevedo, did you want to have contact with Miss Rivera?
Yes.
Are you afraid of her?
No.
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 All right. Do you have any concerns about your safety at all if I were to allow contact between the two of you?
Not at all, Your Honor.
Do you live together?
Yes.
Do you have children in the home?
Yes.
All right. And do you have any concerns about the children's safety if I were to allow contact between the two of you?
Not at all.
All right. Mr. Spitty, do you have any questions?
Have there been previous episodes of violence between you?
No.
Nothing further, Your Honor.
Ms. Custon? All right. Ma'am, you are not to have any hostile contact with Mr. Azevedo. Do you understand what that means?
Any hostile contact, is that what you said? I understand,
You
I
can't-
understand, yes.
You can't have any hostile contact.
Yes.
And you're not to possess any weapons or firearms. I'm going to place you on pretrial release at this time.
Okay.
Do you have any questions about anything that I've ordered?
And I allowed to go back and forth from Boston to Florida, or do I have to stay in Florida?
You are allowed to go back and forth, ma'am. You need to maintain contact with your lawyer. Make sure you're aware of all of your court dates, that you don't miss court. If you miss court, a warrant will be issued for your arrest.
Okay, I understand.
Okay?
Yep.
Thank you. Good morning. Your name?
My treasurer, Butler, ma'am.
All right, so you have two cases this morning. You've got 20 CT 3797, which was a failure to appear for arraignment for driving while license suspended. Mr. Butler?
Yes,
I'm
ma'am.
looking at his driving record. Sir, you don't have any prior convictions for driving while license suspended?
No, ma'am.
Did you want to enter a plea to that case today?
What you mean by that, ma'am?
Your Honor, is this the one?
I really don't
with the
understand.
Yeah.
So the out on bond is actually the exact same case. They issued a notice to appear on the driving license suspended and then gave a no return date and then issued a warrant. So we don't advise him to take a deal.
Okay.
Just to,
So the driving while license suspended is related to the out on bond case?
yes, for some reason they handed him a ticket for that, but then no court date. It's the same date, 6/13.
Let me look.
I'm not even sure how a warrant would be issued because I don't see any notice.
Okay. We have a citation. The citation says to be set. The date is the same.
That's why I told you to make sure.
I hope I go.
You want me to go to the bond.
Yeah, I don't see where notice was provided to Mr. Butler either for the arraignment on June 30th. All right, well, I'm gonna release, Mr. Butler on that case, 20 CT 3797, on his own recognizance. I'm gonna give him, I need a Division 62 arraignment.
You are wiring?
Mm-hmm. On the driving case.
Okay, and it was filled up here for arraignment, right? We don't have the dates for arraignment. Only thing I can think of is emailing, for us to email the JA to see what dates they're setting. Because are they setting those dates right now?
Mr. Butler, do you have a phone number?
I don't have their particular date. It's only if they're getting assigned to an individual.
Mr. Butler,
Yes,
it's a lawyer in courtroom 1. Do you have a phone number so the lawyer can contact you if a court date does?
Yes, ma'am.
Well, they're probably going to give you a court date, but what's your phone number?
321-424-9100.
9100?
Yes, ma'am.
Thank you.
You're welcome, ma'am.
Your Honor, could you appoint us on that? I know that it's a ticket, but
Sure. Mr. Butler, I'm gonna appoint the public defender to help you with that case.
PTC dates.
I'm gonna give him the PTC date. I'm gonna give you a court date of August 3rd
Yes, ma'am.
at 10:30 a.m. It's courtroom 10B. You'll
Yes,
wanna
ma'am.
maintain contact with your lawyer on that case,
Yes.
to see if, you need to actually appear in court or if that would be a virtual appearance, sir.
Yes, ma'am.
And then I'll take no action on the out on bond case.
Okay, thank you, ma'am.
Thank you, Mr. Butler.
Have a blessed day.
You too, sir. All right, well then it looks like we're on the add-on docket. And I just have this one. We still don't have the Creole still hasn't called in yet.
She emailed it and said
She
they won't be
did-
able to sign in until 10:30.
Oh.
And she's in another courtroom right now.
Did she come this afternoon?
Yeah. You want
to move it to the afternoon?
There's no victim.
Okay.
We're gonna do the Creole,
So we'll just put it on
We'll
the
have to
docket.
make that language line. That's fine.
All right, so all we have left is the 33-day motions, and then there's one other out-of-county motion that I have. I haven't looked at the afternoon docket. Is it something that you think we're gonna move or start at 1 o'clock?
There's not as many felonies today. We did 2 of them, so misdemeanors aren't bad. We could definitely move it up. It's up to you. I can do it. Do you think?
So what about noon? That's 2 hours?
Oh, yeah.
Yeah, okay. Everyone's good with that?
I'm agreeable to whatever you want to do.
All right, so but noon gives everyone plenty of time to get ready?
Y'all have one plea, not.
We're gonna do that. I just was trying to figure out when we're gonna.
I just wanted to let you know she's not coming.
Okay. Thank you. So then we'll tell the Creole interpreter for noon.
Okay, I'll email her. I'll see.
So that's Cheyenne Malcolm is not coming, is that right? Okay. 19mm 3390 Cheyenne Malcolm. That was set for a plea. Ms. Custon, your office represents her. Do you just want to reset the plea on my docket when she's able to come to court?
Yes, Your Honor. If you can give me that case number again, I'm sorry.
Sure. It's Osceola as well, though. 19mm 3390.
I'll email them. Thank you.
Sure. All right.
Should be on it, right? I'm gonna see her.
Sorry about that. Did y'all have a James Simmons too?
Mm-hmm. Yes, that's set for bond hearing.
Right.
Is he coming?
Gordon is,
Mr. Simmons is on his way.
No. we're gonna-
He's not here yet, Your Honor.
Can we read
He's on
He's
his
on
way.
his way, though?
Yes.
No problem.
And we do him second session, Your Honor? Mr. Simmons? He's over in another facility.
All right, well, I'll have Jill call his attorney and let him know it'll be this afternoon. That's fine.
Thank you.
I'm gonna keep this.
Your Honor, Simmons is here. Oh, he just showed up. You want to do him now?
Mr. Simmons is here?
Yes.
Okay, we'll take care of that then.
There you go.
Mr. Bond, this is Judge Carter calling from Orange County from the courtroom for your bond hearing. I suppose we will attempt to call you back in the next 5 minutes or so. Thank you. All right, I'm going to do the 33-day motions and then try to call him back. Mr. Simmons?
Yes, ma'am.
Mr. Simmons, I'm going to take care of some other matters, and then I'm going to try to call your lawyer again. If he doesn't answer, we'll have to reset it for after lunch.
After, how long, ma'am?
After lunch.
Okay.
All right, sir? Okay, so here's the 33-day motions. Ms. Fusco, are you ready on 33-day motions?
Yes, Your Honor.
Twenty CF 6784 Taquan Stefine. It's on the add-on.
Yes, Your Honor. On July 6th, there was a notice of non-filing.
I'm going to take this. Okay. Good morning. This is Judge Carter. Good, sir. How are you? No problem. I just had Mr. Simmons here. Let me get him brought back to the podium if I could.
Thank you, Judge.
Sure. All right, Mr. Simmons, your attorney is present on the phone with me this morning. Mr. Vaughn, this is your motion to set bond, so you can proceed.
Thank you, Judge.
I'm sorry, Your Honor, I can't hear him.
Previously been charged with battery in Marion County, and we had a bond set in about $250 in that particular case. There was a failure to appear, but that was addressed with a $250 bond. That hearing was about a week and a half ago or so. This one is a stalking charge that is the same victim. It's a different charge. Since the filing of the battery charge, the injunction itself, the victim has dismissed the injunction. My client, I can ask him questions about where he lives, what his business is, but this little predicate here, the victim in this case has already dismissed the injunction. So I'm prepared to have my client testify at this point, Judge.
Sure, and then just for a point of clarification, this was a new law offense, correct? It wasn't a case that was previously filed. It wasn't a failure to appear. It was a new warrant arrest.
Yes, it's a different charge. And this is a battery, this is a stalking charge. Based on the injunction that was dismissed.
All right, so Mr. Simmons is legally entitled to bond.
Yes.
Okay.
Is he sworn in at this point?
He has not been sworn in. Mr. Simmons, could you raise your right hand, please?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
Okay, go ahead and state your full name, please.
Yes.
Hopefully.
Is it difficult for you to hear Mr. Vaughn?
I can hear him, but it's kind of difficult, Judge.
All right. Mr. Vaughn, do you have any objection to me asking him some questions to establish his ties to the community?
Oh, that's fine, Judge.
Okay, I think it just might be easier in terms of communication. Mr. Simmons, where do you live, sir?
I live in Ocala, Florida now.
And did you say Polk County?
No, Marion County, Ocala, Florida.
You live in Ocala, okay.
Yes, ma'am.
And how long have you lived in Florida?
I've lived in Florida my entire life.
All right. And are you employed?
Yes, ma'am.
Where do you work?
I'm a AAA construction manager, principal vice president.
How long have you worked there?
We had this company, me and my brother, since 2004.
This is your company, sir?
Yes, me and my brother's company.
Okay.
We do construction management and investment, building houses, real estate.
All right. Do you own a home here in Ocala?
Oh, yes, ma'am.
All right. All right, Mr. Vaughn, I don't have any other questions for Mr. Simmons. Is there anything that I didn't ask that you'd like to be asked?
Your Honor, if I may.
Just a couple of questions in reference to my client having his ties to community and that he will return back to his residence in Marion County, that it should be released with a reasonable bond.
Okay. Ms. Fusco?
It's just our position that this should be heard in Marion County and that we have not been able to get in contact with the victim. He said that there has been some action on the injunction, but that wasn't attached to the motion, and so we were particularly object to anything being done in regard to the injunction without contact of the victim or without any of that paperwork being presented with the motion, but would ask that both of these matters be heard in Marion County.
Okay. So these cases are to be heard in Orange County given the administrative orders that the Supreme Court of Florida entered, because Mr. Simmons cannot be transported to Marion County to have a bond hearing. This is a misdemeanor offense. Mr. Simmons is legally entitled to have a bond on this offense. Mr. Vaughn has coordinated it as he should have through the proper contacts in Marion County. So the bond motion is properly set here in Orange County. Did you have any questions for Mr. Simmons about his ties to the community?
No, Your Honor.
Okay. Mr. Simmons, you are not to have any contact with the victim in this case. You are not to possess any weapons or firearms, and you're to maintain a separate residence from the alleged victim. I'm going to set your bond in the amount of $500, sir.
Yes, ma'am. Thank you, Your Honor.
Anything else, Mr. Vaughn?
That's all I have. Thanks for your help, Judge.
All right, sir. Thank you.
Your Honor, he has 2 more counts.
You what?
It's 2 counts.
So you can do $250 on each.
$250 each.
Is it 2 counts total?
Mm-hmm.
Yes. So for a $500 total, so $215.
Okay. Judge, you want to break it down on here, or?
Mr. Vaughn, you have 2 counts in this matter, so your bond total is still $250. Or, I'm sorry, your bond total is still $500, but it's $250 on each count.
This defendant is going out ROR, and it's a traffic case.
Thank you, sir.
So we said,
Thank you.
and I'll show it to you. Go through your stuff.
Have the case number, it's not on the affidavit.
The case number is 2020 CF 822580.
Thank you, Denise. Okay, this is Carla Rodriguez. It was recalled from this morning. So, count 1 is a PDL. Courtney from PTR, you're telling me that pretrial is not going to supervise that count, correct? Correct. Okay, but I did set a bond on it.
Yeah.
Okay. Ms. Fusco, you were asking to be heard?
Yes, Your Honor, just referring to the statutes that were provided, the weight was over the 4.0, it was 4.2, and he was in possession of a firearm, so we're asking the court to find proof evident or presumption of great and hold him at no bond.
Ms. Hupton?
Your Honor, we leave it at the discretion of the court.
So I do agree that the state has met their burden to establish that there is proof evident or presumption of great. However, I'm going to exercise my discretion and move the bond to set and delete the PTR condition.
Your Honor, are you going to keep the PTR for 2 and 3 or delete it from the whole case?
No, I'll just delete PTR.
Okay.
Thank you. I'll just write on here the conditions that I said.
Yeah. I'm gonna leave it how she did it because she had
Thank you, Jenny.
the information from they put it, it should have been this count, but she had it. You get what I'm saying?
Excuse me, Judge, are we gonna contact the Creole interpreter right now, or are we gonna wait on that?
She's on the line.
She's online. Okay.
Okay.
One second. This 120 CF 6084 should be granted. Am I getting her here?
She's on the black phone, so do we just get the phone?
Oh. Good afternoon. Do I have the interpreter on the line?
Yes. Hi. Good morning. Good afternoon.
Yes, ma'am. Good afternoon. We're going to go ahead and call the case. This is 20 CF 8214. Sir, good afternoon. Please tell me your name.
Bonjour, monsieur. Bon après-midi. Dis-moi qui j'en relais, s'il vous plaît.
Oui, moi, elle est Guzman Cassis.
My name is Guzman Cassis.
Sir, you were arrested for aggravated assault, domestic violence.
Monsieur, vous t'es arrêté parce que vous t'es fait violence domestique et attaque grave?
Non, moi,
There is probable cause.
Tiens assez évidence.
I'm appointing the public defender to represent you.
Ma bonne défenseur public pour représenter.
You are not to have any contact with the victim
Ou pas capable de gagner aucun contact avec victime là?
You're not to return to the scene.
Ou pas capable de retourner côté bagarre la t'es faite?
You're not to possess any weapons or firearms.
Ou pas capable de gagner aucune arme ou bien aucune arme à feu?
Your bond is $2,500.
Ou gain au caution un bond de $2,500.
I am revoking the releases in 19MM 649.
Your
And
Honor, on both those cases have been found incompetent. We request the release not be revoked.
Based upon the facts of this new case and then what he's out on bond for, or out on release for, I am going to revoke the bonds. Mr. Spencer can have those heard in front of the trial judge, and they can modify the conditional release to address this case and whatever other needs Mr. Guzman may have. So I'm going to set those at none.
Il peut retirer le bond que vous avez gagné et relâche que vous avez gagné sur 19 MM 649.
Thank you, Mr. Guzman.
OK, merci, Monsieur Guzman. Is that the only one for me, Your Honor?
It is, ma'am. Thank you very much.
You are welcome. Thank you. Bye-bye.
Bye-bye. Good afternoon, your name? Excuse me?
Kevin Bango.
Mr. Bengo, this is 20MM 4925. You were arrested for trespassing a structure or a conveyance. There's probable cause, sir. I'll appoint the public defender to represent you. Was there an offer for Mr. Bengo?
Yes, Your Honor. Adjudication of guilt, 2 days with 2 days credit time served. Court costs, no return to the scene of the trespass at 2827 West Livingston Street.
Mr. Bengo, did you want to accept the state's offer?
Yes, ma'am.
Okay. Did you read the plea form before court this afternoon?
Yes, ma'am.
Do you have any questions about any of the rights on the form?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that this plea will subject you to deportation?
Yes, ma'am.
All right, sir. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
I'll accept your plea, adjudicate you guilty, sentence you to 2 days in jail. You have credit for 2 days time served. You will have to pay court costs, which are due by July 7th of 2021. You're not to return to the scene. You have 30 days to appeal the judgment and sentence of the court in writing. Thank you, Mr. Bango. Good afternoon, sir.
Good afternoon, young lady.
Tell me your name, please.
Reginald Cook.
Mr. Cook, this is 20MM 4909. You were arrested for possession of drug paraphernalia.
Yes,
There
ma'am.
is probable cause. Is there an offer for Mr. Cook?
Adjudication of guilt, 3 days with credit time served. Court costs.
Mr. Cook, did you want to accept that offer? You'll be released today, sir.
Ma'am?
Did you want to accept the state's offer of 3 days in jail? You've got credit for 2 days. You'll be released today.
Yes, ma'am.
All right. Did you read the plea form before court?
Yes, ma'am.
Do you have any questions about any of the rights on the form?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, sir, I will accept your plea, adjudicate you guilty, sentence you to 3 days in jail. You have credit for 2 days time served. You will have to pay court costs, which are going to be due by July 7th of 2021. You have 30 days to appeal the judgment and sentence of the court in writing.
Thank you.
Thank you, sir.
Thank you.
afternoon, your name?
It's Mac.
All right, how about Mr. Hulse?
Mental health, Your Honor.
All right. Ms. Custon, I'm going to appoint your office to represent him. Did you want to waive his appearance?
Yes, Your Honor.
All right, that's 20 MM 4908. He was arrested for assault, criminal mischief, and petty theft. There's probable cause. He's not to return to the racetrack or the roadway. I'm sorry, the speedway. And bond on count 1 is $250, and I'll say the bond on counts 2 and counts 3. I'll take no action on the out on cases. And you're Mr. Mack, is that correct?
Yes, ma'am.
All right, sir, you're here in 20 MM 4930. You were arrested for trespass on property after warning. There is probable cause, sir. Actually, is there an offer for Mr. Mack?
Yes, Your Honor. Adjudication of guilt, 2 days with 2 days credit time served, court costs, no return to the scene of the link station at 445 North Garland Avenue, abide by trespass warning.
Mr. Mack, did you want to accept that offer?
What's the offer again? Ms.
It's credit for time served.
Yes.
Okay. Did you read the plea form before court?
Yes, ma'am.
All right, you understand you can't return to the Lynx bus station?
Yes, ma'am.
Okay. Do you have any questions about any of the rights that you're giving up?
No, ma'am.
Are you on probation?
No, ma'am.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, Mr. Mack, I'm going to accept your plea, adjudicate you guilty, sentence you to 2 days in jail. You have credit for 2 days time served. You're not to return to the Lynx bus station, and you need to abide by that trespass warning. You will have to pay court costs, which are due by July 7th of 2021. You have 30 days to appeal the judgment and sentence of the court in writing, sir. Thank you.
Okay.
Good afternoon. Your name?
John Tavis McGee.
Mr. McGee, this is case number 20MM4933. You were arrested for battery. There's probable cause. I will appoint the public defender to represent you. You're not to have any contact with the victim or possess any weapons or firearms. Courtney, can I place him on pretrial release? Yes, sir. Okay. Mr. McGee, I'm going to place you on pretrial release at this time.
What's that?
Thank you, sir. Do you have a question?
Yeah, I do have a question. I'm sorry. Yes,
Mr. McGee, did you have a question?
Yes, I do have a question.
Go ahead, sir.
I wrote a statement before the police came over there to my house.
So,
when the
Mr.
battery.
McGee, wait just a second. Listen. That doesn't sound like a question to me. I think that's, you wanted to talk about the facts of your case, so I'm going to ask you not to do that and talk to your lawyer about that, okay?
Yes, ma'am.
All right. Thank you, sir.
No problem.
Good afternoon. Are you Mr. Williams?
How you doing?
Sir, this is 20MM4929. You were arrested for trespass on property after warning. There is probable cause. Is there an offer for Mr. Williams?
Yes, Your Honor. Adjudication of guilt, 2 days with 2 days credit time served, court costs, no return to the scene of the link station at 445 North Garland Avenue, abide by trespass warning.
Mr. Williams, did you want to accept the plea today? It would be credit for time served, no return to the Lynx bus station.
Yes, ma'am.
All right. Did you read the plea form before court?
Yes.
Do you have any questions about any of the rights on the form?
No.
Are you on probation?
No.
Do you understand if you are not a U.S. citizen that this plea will subject you to deportation?
Yes.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No.
All right, sir. I will accept your plea, adjudicate you guilty, sentence you to 2 days in jail. You have credit for 2 days time served. You will have to pay court costs. Those are going to be due by July 7th of 2021. You're not to return to the Lynx bus station, and you have 30 days to appeal the judgment and sentence of the court in writing. Thank you, Mr. Williams.
Thank you.
Good afternoon. Are you Mr. Yaddo?
Yeah.
Yes. Yes? All right, Mr. Yaddo. You're here in 20 M4910. You were arrested for trespass on property after warning and resisting officer without violence. There is probable cause. I'll appoint the public defender to represent
What's the
you.
probable cause? And no, I wasn't on the property.
Mr. Yaddo, that's something you'll have to talk with your lawyer about.
Huh?
Ms. Custon, the out on bond cases, is there any competency issues pending in those cases?
No, you can resolve all those cases if you want.
I was never
Okay.
properly on the property.
Mr.
Yeah.
Yaddo, did you want to enter a plea to all of your cases
Yeah.
today and resolve them?
Not guilty.
All right, sir, no problem. I'm going to stay your bond at 500 on count 1 and 100 on count 2. You're not to return to the Disney properties. And I'm not going to take any action on your out on bond cases. Thank you, sir. Good afternoon. Your name?
Johnny Dorsey.
Mr. Dorsey, you are here in 20 MM 295. You were arrested for violating your conditions of pretrial release. Okay, the public defender was previously appointed. At this time, your bond is set at none, sir. You'll have to have your lawyer file a bond motion to determine if the judge would like to set a bond.
I don't understand, Your Honor. I don't have a lawyer.
The public defender's office represents you, sir. So there should be a form there in the courtroom with the contact information that'll inform you on how to get in touch with their office.
Okay, Your Honor, if I was detained at my job, I didn't know I had a warrant out or didn't know this was happening.
Mr. Dorsey, do you have a phone number?
Huh?
Mr.
Yes,
Dorsey,
ma'am.
do you have a phone number?
Yes, ma'am.
Can you provide it, and I'll give it to your lawyer right now to keep you posted.
407-979-6158.
Okay, and they'll keep you posted. There's nothing we can do about your bond today, okay?
All right. My other question is, what do I do? Like, do I stay here until the next court date?
Well, until your lawyer files the bond motion and it's heard by the judge.
You can delete
Okay.
Okay? Thank you, sir.
Your Honor, next on the list is Crystal Rodriguez, bonded.
Okay? Are you Mr. Revere?
Yes, ma'am.
All right. So you were arrested in 20 ML 749 for violating the city ordinance for being in a condemned house.
Yes,
There's
ma'am.
probable cause. Is there an offer for Mr. Revere?
Yes, Your Honor. Adjudication of guilt, 2 days with 2 days credit time served, court costs, no return to the scene at 2831 Livingston Street, and abide by trespass warning.
Mr. Revere, did you want to accept that offer, sir?
Yes, I take the offer, ma'am.
Okay. Did you have a chance to read the plea form before court?
Yes, yes. I didn't, ma'am,
Sir, go ahead.
I just kind of glanced through it, but I understand it.
Okay. Well, did you have any questions about any of the rights on the form that you're giving up?
No, ma'am, no.
All right. Are you on probation?
No, ma'am. No,
Do you understand if... Excuse me? Mr. Revere, I didn't catch the last part.
What she said? I couldn't hear. She said repeat the last part. Oh, yeah, I understand.
Okay. Are you on probation?
No, ma'am.
Okay. Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, sir, I will accept your plea, adjudicate you guilty, sentence you to 2 days in jail. You have credit for 2 days' time served. You'll have to pay court costs, which will be due by July 7th of 2021.
Yes,
You have
ma'am.
30 days. You have 30 days to appeal the judgment and sentence of the court in writing.
Okay. So
Thank you, Mr. Revere.
So basically, I have time, sir. Okay.
Yes, sir.
Okay, thank you, ma'am.
Now, the next person on the docket, Cherry Winston, mental health.
You think Mr. Cherry's going to be able to make it to court tomorrow?
He might be on
All right, I'm going to reset Mr. Cherry's case for
it,
tomorrow.
he's not one of them, he's not in one of those.
Okay. Good afternoon, your name?
Roger Christopher.
Mr. Christopher, you are here in 20 CF 7142, sir. You were arrested pursuant to a warrant for failing to register as required. I will
Right.
put the public defender to represent you. Your bond is $1,000, sir.
All right, thank you, ma'am.
Thank you, sir. Good afternoon, your name?
Good morning.
Are you Mr. Graham?
Good morning.
This is 20 CF 8216. You were arrested for aggravated assault with a weapon. There's probable cause. I'm going to appoint a public defender to represent you. You're not to have any contact with the victim. You're not to return to the scene. You are not to possess any weapons or firearms, sir. Corey, does he qualify for pre-trial?
He did not qualify during his interview.
For what?
He did not qualify during his interview. It looked like they tried to investigate his community ties, but he didn't qualify.
Your Honor, may I ask him, Mr. Graham, some questions?
Sure.
Actually needs to be sworn.
Ma'am, can I tell you something real quick?
Hold on,
One second, Mr. Graham, okay?
Does he need to be sworn?
Sure. Mr. Graham, could you please raise your right hand to be sworn in?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
Mr. Graham, you can't see me, but I'm a public defender in courtroom 1, just on the other side of the wall from you. I'm just going to ask you some questions about your community ties and just some information about you to see if we can get you out of here without paying any money.
Yes, ma'am, I appreciate that.
Okay, how long have you lived in Orlando?
I've been in Orlando for 5 years now, ma'am.
And where do you live?
I live on 7181 Balboa Drive in Orlando.
Have you lived there since you've been in Orlando?
I've been there since the beginning of 2017, when me and my wife separated.
Do you live with anyone?
My daughter, my 18-year-old daughter.
Does your daughter live in Orlando permanently?
Yeah, she's just graduated from McCoy High School.
What's her name?
Kiana Palmer.
Do you work in Orlando?
I was at SeaWorld for the last 5 years until I got furloughed, ma'am,
So how long have you been furloughed for?
since April 1st.
Do you plan on finding another job in Orlando?
I'm not sure yet, ma'am. I'm trying to see if I can get disability. I just got out of the hospital a couple of weeks ago because of my kidney failure and I had heart failure.
Where were you in the hospital in Orlando?
No, ma'am. I had actually went to visit my daughter in South Carolina and I'm going in the hospital down there.
How many daughters do you have?
I have 2 daughters.
And do you have any other family that lives in Orlando?
Just my wife that I'm separated from. That's it, ma'am.
It looks like you were in the military. Do you go to the VA?
Yes, ma'am. That's why I get.
Do you go to the? Go ahead.
That's why I get my all my medical stuff done.
In Orlando?
Yes, ma'am. At Lake Nona. Lake Nona and Lake Baldwin.
How often do you go?
Well, depending on what the appointment is, most of them now are telephone calls because of COVID-19. But I was going regular because, like I said, because of my kidney failure and stuff. So I see my nephrologist a lot, and now I'm on. Now I just started dialysis like 3 weeks ago. So.
Okay, thank you. No further questions?
Mr. Wood, do you have any questions?
No, Your Honor.
Courtney, I can call over to you, right?
Yes, Your Honor.
All right. Mr. Graham, I'm going to place you on pretrial release at this time. It looks to me like this may have been a neighbor based upon the address. You can't return to that neighbor's house. Do you understand?
Yes, ma'am.
Okay, sir. All right. Thank you, Mr. Graham.
Thank you.
Good afternoon, sir. Your name?
Lee Gresham.
Mr. Gresham, sir, you were arrested pursuant to a probable cause warrant in 20 CF 6194 for driving while license revoked as a habitual offender in possession of cannabis less than 20 grams. I'll appoint the public defender to represent you, sir. Bond on count 1 is $2,500. I'm going to ROR you on count 2.
Okay.
And he has reporting requirements.
Mr. Gresham, you also have reporting requirements when you are released from the jail.
Yes, ma'am.
All right, thank you, sir.
Yes, ma'am.
Your Honor, the individual person on the docket, I put that to Harrison as well.
All right. Ms. Custon, I am going to appoint your office. Did you want to waive the appearance?
Yes, Your Honor.
All right. That's case number. Oh, 20 CF 8041. She was arrested for petty theft with 2 prior convictions pursuant to a probable cause warrant. She's not to return to the scene. And her bond is $500. Good afternoon, Mr. Jarvis.
How you doing, ma'am?
Sir, you are here in case number 20 CF 8199. You were arrested for burglary of an occupied structure and criminal mischief less than $200. There is probable cause. I will appoint the public defender to represent you. You're not to return to the scene. You're not to have any contact with the victim.
And Your Honor, his out-on bond was no info yesterday, so we took it out.
Thank you, Courtney. Okay.
He's really like.
Bond on count 1 is $2,500. Bond on count 2 is $100.
Your Honor, it says that he doesn't qualify for PTR because he has an open case. I'm not sure if this charge does qualify anyways, but could he be interviewed as well since that case is no longer open?
Yes, he would, because burglary of occupied structure would be a case in which he would.
He just needs to be interviewed.
Okay.
So I'll do PTR or bond, sir. They're going to come interview you to see if you qualify for pretrial release.
Oh, thank you, ma'am.
All right, thank you, sir. Good afternoon. Tell me your name, please.
Romaro Jenkins.
Mr. Jenkins, this is 20 CF 8211. You were arrested for grand theft of a motor vehicle. There's probable cause. I'm going to appoint the public defender to represent you. Your bond is $1,000, and I'm revoking the bond in 20 CF 6100. That will be set at none, sir. Thank you. Good afternoon, sir. Tell me your name, please.
Hold on for a minute, Your Honor.
No problem.
Yeah, I can't hear very well.
Can you hear?
That sounds much better.
Okay.
Mr. Johnson, can you hear me?
Yes, ma'am.
All right, sir. You have 2 cases. I will appoint the public defender to represent you in both. this afternoon. You have 20 CF 8181. You were arrested for possession of methamphetamine and possession of drug paraphernalia, as well as 20 CT 850. You were arrested for driving while license suspended. There's probable cause, sir. I'm going to appoint a public defender, as I said, to represent you. You are not to possess or consume any controlled substances without a valid prescription. You are not to drive without a valid driver's license. And I'm going to release you on your own recognizance at this time, sir.
Thank you, ma'am.
Thank you. Good afternoon. Are you Mr. Johnson?
How you doing?
Sir, this is 20 CF 8220. You were arrested for aggravated battery, great bodily harm. There is probable cause. I'll appoint the public defender to represent you. Your bond is $3,500. You are not to have any contact with the victim, return to the scene, or possess any weapons or firearms, sir.
Yes, ma'am.
Thank you. Good afternoon. Your name?
How you doing?
Did you say Christopher Lewis?
Yes.
All right, sir. You have 20 CF 8215, shooting or throwing into an occupied vehicle, 2 counts, aggravated assault with intent to commit a felony, use of a firearm or weapon in the commission of a felony, and possession of a firearm by a convicted felon. There's probable cause for those offenses, sir. You also have 20 CF 8187, possession of a firearm by a convicted felon, and possession of methamphetamine with a weapon. There's also probable cause for those, and driving without a valid driver's license, and 20 CT 4191. 20 CT 4191 bond will be $100. And then CF 8187 bond will, on count 1 is going to be $1,500. Bond on count 2 is $150. And in 20 CF 8215, count 1 bond is $5,000, and I'll stay the bond on counts 2 through 5 at $150. You're not to have any contact with the victim or victims. You're not to return to the scene. You are not to possess any weapons or firearms, sir. Thank you, Mr. Lewis.
Thank you.
Good afternoon. Your name, sir?
Oh, I'm sorry, Tariq Nichols.
Mr. Nichols, you were here in 20 CF 8218. You were arrested for grand theft of a motor vehicle. There is probable cause. I'll appoint the public defender to represent you. You are not to return to the scene or have any contact with the victim or co-defendant. Your bond is $1,000, and I'm revoking your release in 20 CF 5215.
So can I speak? Can I speak, ma'am?
Mr. Nichols, please don't speak. This is your public defender. I'm emailing your attorney on your out on bond right now to try to see if we can do something about a bond, okay?
Yes, ma'am.
Just a second, Mr. Nichols. I'm not done. Okay. I am revoking the bond in that case, and information was filed. It's set for arraignment. Good afternoon. Tell me your name, please.
Tavares Robinson.
Mr. Robinson, sir, you are here in 20 CF 8188. You were arrested for burglary of a conveyance. There is probable cause. I'll appoint the public defender to represent you. Your bond is $2,500. I did look up the out on bond case. It's set for a plea in front of, I think it says Cameron. And he's represented by Jeff Stone, so that it's not a public defender case. Mr. Robinson, I'm going to revoke your pretrial release on your out on bond case. I'm going to set bond in that case at $100.
All right.
Get in touch with Mr. Stone. You know your case is set for a plea hearing.
Yes, ma'am. That's it.
All right, thank you, sir. Good afternoon. Tell me your name, please.
Travius Swanson.
Mr. Swanson, this is 20 CF 8219. You were arrested for grand theft of a motor vehicle. There is probable cause. I'm appointing the public defender to represent you. Your bond is $1,000. You're not to have any contact with the co-defendants or the victim, and you're not to return to the scene, sir. Thank you.
I got a phone. All right, thank you, sir. Have a good.
Good afternoon. Tell me your name, please.
Gregory Trowbridge.
Mr. Trowbridge, you are here in case number 20 CF 8186. You were arrested for possession of heroin. There is probable cause. I will appoint the public defender to represent you.
Your Honor, can we take care of that case even though it's Osceola? The Allen bond?
Is there any way to tell how much time you would have on that case, sir? If you would have 2 days here, right?
It's a hold, so if you revoke it and remand him, it's just 1 day.
Mr. Trowbridge, did you want to resolve the trespass case that you have in Osceola County today?
What would be the, how would we resolve it?
You would enter a plea. You would be given,
And the last time, Osceola kicked it back out when we did one. So we might want to email and figure out exactly how much it was. Because when we did it, the order wasn't enough because it didn't have the correct time served on it. So
well, what if I put the exact time served?
we have it.
I'll put 1 day. That's what I'm going to give him.
Oh, okay. So he wasn't arrested in Osceola on this case before?
I think he was, but can we just do, you're only going to get 1 day credit, just to be safe?
We can, but the last time the time served was wrong, so they resubmitted it for us to do a corrected order. So it's up to you. I'll just write whatever you say.
The only one that I know that came back from Osceola was the judge wanted it corrected as to like the negotiated part.
I'll type whatever you say on the order, hopefully.
Okay. Well, I'm willing to do it, and if it comes back. So a correction sent it back?
Yes.
Huh. Okay. Mr. Trowbridge, were you arrested on the Osceola County case?
Yes, ma'am. And then I was released on PTR, and I've been on PTR since.
Okay. It probably has 2 days from that. Well, I don't know. Today,
Can we make the plea without even any credit for any jail? No. I can probably look it up somehow.
I don't have enough facts to do like a fine, or I don't have enough information about the case really. So I'm just not going to take any action on it. Ms. Custon, do you have access to any?
It is our case, and that's why I know that he's able to resolve it. Let me just see what I got in here. So, Mr. Trowbridge, were you only in for 1 day and then you got pretrial release?
No, I was in there for technically 3 days. It
I stayed there overnight. I stayed there 2 overnights, and the next morning I got released. Because when I came in, I had conditions of COVID, so they had me in a special room, and then I stayed in there. I didn't even see the judge. They brought me paperwork for the PTR.
You're not on probation, correct?
No, ma'am.
Your Honor, the police report says that he was on a bench sleeping outside of a hotel. He had been trespassed for a year. They called the police and he had been trespassed from that location, and he was there before the year was up. So you arrested him and he was held on a $250 bond, and they gave him free trial release. I can't see the exact days because I don't have the clerk's. Are you able to see the Osceola clerk system?
No, just case management profile.
Could we do 4 days? And then Mr. Trowbridge, if for some reason something's weird, you might end up in here for 3 more days, but it should be that you're getting credit because you're telling us it's 3 days.
Okay, so how many more days would I have to do into here?
Well, it depends if
3 days. Well, before, because if it did 3, he still gets the credit for the 1 anyway.
it would be 3 more from now unless the system has it correct as the amount of days you said you'd stay, and then you would get released today, but I don't think that would go through today. So I think at least tomorrow, but possibly 2 more days after that.
Okay, and then what would happen with this case that we got?
Did you give the release conditions on that one?
I was going to release Mr. Robich's ROR on that case.
So you'd be released, but you have to come back and you still have to call your lawyer. So that's a felony. So you're going to get either the state's going to file the charges and you'll have to come back for an arraignment, but you won't have the misdemeanor holding you anymore, and you won't have to report to Osceola if you were to take a 4-day offer.
So right now, we don't know if it's 3 days, 4 days, but it's definitely a couple days. Is that what you're saying?
The issue is it's an Osceola case and we're in Orange County. So the judge does have jurisdiction to resolve the case, but as for the days, none of us have access to it. So there's a chance that, the information you're telling us will align with the information from the jail, but we don't know that. So if it doesn't, then you would either do you not want to resolve and do this at a different time? Because we can always just do that.
I'd like to do that because with me restarting my new job and my mother being disabled, I definitely would like to get back on out so I can get back to work as soon as possible. Because I was also looking at, when I talked to the public defender about probation or getting my time lessened for Osceola or just doing it on the weekends. That was something that was supposed to get brought up on the 14th when I went to court.
All right, Mr. Trowbridge, I'm not going to take any action, but check in with your public defender in Osceola County on that case, okay?
Okay, so what happens with this one?
You're going to be released today. You're not to possess or consume any alcohol or controlled substances,
Yes, ma'am.
and you're going to be tested through pretrial release.
Yes, ma'am.
All right, thank you.
Thank you.
That'll be the left side.
Good afternoon, your name?
Robert Bauer.
Mr. Bauer, you were arrested pursuant to a probable cause warrant in 20 CF 8203 for battery and attempted sexual battery. I will appoint the public defender to represent you in all of your cases this afternoon. Bond on count 1 is 500. Bond on count 2 is 5,000. You're not to have any contact with the victim.
Your Honor, I don't even know. I never got a copy of, what do they call it, an affidavit. That I don't know who, where, when, what this came from.
Okay, sir, I understand. Ms. Custon, can you get him a copy sent
Yes.
of the affidavit?
Yes, Your Honor.
Your public defender's in the courtroom with me, Mr. Bauer, and she's going to make sure that you get a copy of the affidavit.
Okay, is the bond still the same?
The bond is the same, however, you have violations of probation cases in 06 CF 17842 based upon the facts contained in the arrest affidavit, and Also in 06 CF 1835, which is an Osceola County case, the violations of probation cases, the bond is going to be set at none, sir. And as I said, I've appointed the public defender to assist you with those cases.
Okay, so I have no bond?
That's right. You also have reporting requirements, sir, when you're released from the jail.
Reporting requirements from what?
When you're released from the jail, you have reporting requirements.
Oh,
You have sex offender
to
reporting
probation,
requirements.
yes, of course.
Okay, sir, thank you. Sir, good afternoon. Your name?
Kareem Young.
Mr. Young, you were arrested pursuant to a probable cause warrant in 20 CF 6814 for delivery of cocaine within 1,000 feet of a park. I'm going to appoint the public defender's office to represent you. You're not to return to the scene. Your bond is going to be $2,500. I'm revoking the bond in 20 CF.
Revoking?
Just a minute.
Oh.
All right, Mr. Young, I'm not revoking your out on bond case because the alleged offense date in 20 CF 6814 is in January of this year, and your arrest date on the out on bond case is 6/2 of this year. So that bond is going to remain intact. You do have a violation of probation in 19 CF 12383 based upon the arrest and the new case. So that bond on the VOP is going to be set at none. And you'll need to contact the public defender to help you with that case. You'll see Judge Whitehead in the next 7 to 10 days, sir.
Your Honor, the out on bond case, what's the case number? I can't find it. Is it
20 CF 6831, and it says it's either A or BO. I'm not sure
He's
what.
B.
He's B.
Do you see that we've been appointed?
I don't
Did
know.
anybody, could you just appoint us just in case?
Sure. I'm going to appoint the public defender to represent you, sir, on your out on bond case. So just to recap everything, your violation of probation, you don't have a bond. You'll need to get in touch with the PD on that case. You're going to see Judge Whitehead in 7 to 10 days in that one. You still have the other pending case, which I didn't revoke, and then you have the new case, and your bond is $2,500, and you're not to return to the scene in that case.
You said you didn't revoke the case before that.
I didn't.
Oh, okay. All right.
All right,
Thank
sir?
you.
Thank you. Good afternoon. Your name?
Jason Cripps.
Mr. Cripps, you are here for an out-of-county warrant out of Brevard County related to grand theft.
Yes,
It's
ma'am.
like it's a violation of community control along with possession of heroin and possession of a lazopram.
Yeah, it's
At
all,
this time, sir, along with possession of a controlled substance. Your bond on the Brevard County cases, sir, at this time is set at none. I'm going to appoint the public defender here in Orange County to help you coordinate with Brevard County. We'll also reach out to Brevard County to see if they'd like to make any modifications to your bond, sir.
okay.
Once I receive a response from Brevard County, we'll bring you back to court to let you know what the judge decided.
Okay, so I'm not going to Brevard County.
Excuse me?
I'm not going to Brevard County. They're not coming to get me.
They're not transporting inmates right now due to the COVID virus.
Okay,
That's why I've appointed the public defender here in Orange County to help you with your cases.
okay.
All right, thank you.
All right, thank you.
Your Honor, the next person on the docket is Jose Flores Avila, medical.
All right. That's a Lake County case. I'm going to appoint the Orange County Public Defender to assist him. His bond is to remain at none at this time. Sir, are you Mr. Miles?
Yes, ma'am.
Mr. Miles, you are here for an out-of-county warrant out of Seminole County for burglary of a structure and grand theft. Your bond on count 1 is $8,000. Your bond on count 2 is $3,000. I will appoint the public defender here in Orange County to represent you, sir, and help you coordinate with Seminole County. We will also reach out to the judge in Seminole County to see if they'd like to make any modifications to your bond. Once we receive a response from Seminole County, I'll bring you back to court to let you know what that was.
Okay.
All right, sir, thank you.
The next person on the docket is yours. Put it on and Tiago.
All right, and that's a warrant out of Washington County. I'll appoint the Orange County Public Defender here to represent him. And his bond is to remain at none.
I'm sorry, Judge, what was his reason for not being here?
It was medical, correct?
Yes,
Yes, okay. All right, and then if there's nothing else, then court will be in recess.
Bringing all that water. She be flying through that thing, you know? Top of her life.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has not been sworn in yet today.
All right, good morning, Mr. Morales. Do you solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability?
I do.
All right, Mr. Morales, we're here at this time in a fugitive case. This is case 20FW28 involving Mr. Jose Luis Marrero. Mr. Marrero is present at the jail, so he's being seen via video and does not have the headset on. So, Mr. Marrero, good morning, sir. If you'll please raise your right hand.
Buenos días, señor Marrero. Levante la mano derecha, por favor.
Do you solemnly,
I do already.
do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Jura solemnemente o promete que el testimonio que está a punto de dar será la verdad, toda la verdad y solamente la verdad?
Lo juro.
I swear.
You can put your hand down, sir.
Baje la mano.
Please tell us your name.
¿Cómo se llama usted?
José Luis Majero.
José Luis Marrero.
What is your date of birth, sir?
Fecha de nacimiento?
6/8 del 48.
6/8/48.
Mr. Marrero, you've been taken into custody here in Osceola County on a warrant out of the state of Pennsylvania.
Señor Marrero, usted fue arrestado aquí en el condado de Osceola por una orden de arresto del estado de Pensilvania.
Eso es cierto.
That's true.
The warrant is out of the York County, Pennsylvania, and it is for failure to appear on a charge of driving while under the influence.
Y esa orden de arresto procede del condado de York, en Pensilvania, y el motivo es por no haberse presentado a una vista donde se le acusa de haber conducido bajo los efectos.
You have the right to contest your extradition back to the state of Pennsylvania, or you can waive that right and agree to be voluntarily returned to that state.
Usted tiene el derecho a disputar la extradición de regreso a ese estado, o usted puede renunciar a ese derecho de disputar o pelear eso y consentir o de manera voluntaria estar de acuerdo a que se lo agresen allá.
Yo quiero ir voluntariamente para yo arreglar ese caso que tengo en la corte allá en York, PA.
Well, I'd like to voluntarily go to York, PA, so I can resolve the case that I have there.
Okay, well, let me finish explaining some things to you, and then we'll see what it is you wish to do.
Permítame terminarle de explicar algunas cosas primero y luego entonces nos deja saber cuál es su decisión.
Okay.
If you do choose to waive your right to contest extradition, we will notify the state of Pennsylvania that they have 10 business days to come pick you up.
Si es que usted decidiera, si usted decidiera renunciar a su derecho de pelear la extradición o disputar la de extradición, nosotros le notificaríamos al Estado de Pensilvania de que tienen 10 días hábiles o laborales para venirlo a recoger.
If they do not pick you up within 10 business days, you'll be brought back before the court and we will determine the reason they have failed to pick you up and whether or not you should continue to be held.
Y si no lo vienen a recoger dentro de 10 días, entonces usted regresaría a presentarse o comparecer delante de un juez, donde hablaríamos del motivo de por qué no lo han venido a recoger y determinar si es que a usted todavía debería ser detenido o no.
If you choose to contest extradition to Pennsylvania, I will schedule a hearing within 30 days. That period can be extended up to an additional 90 days, an additional 60 days for a total of 90 days, in order to allow the authorities there to obtain a warrant from the governor of Pennsylvania.
Ahora, si usted desea disputar o pelear la extradición de regreso al estado de Pensilvania, entonces se programaría una audiencia de aquí a unos 30 días, o se podría extender hasta 60 otros 60 días después de eso, para un total de 90 días, para permitirle tiempo al estado de Pensilvania para que ellos obtengan una orden de arresto, para que las autoridades obtengan una orden de arresto del gobernador.
If the authorities in Pennsylvania obtain a governor's warrant, that would be forwarded to the governor of the state of Florida, who would review the paperwork and determine whether or not to issue what we call a rendition warrant ordering your return to Pennsylvania.
Your Honor, may the interpreter just have one moment, please?
You may.
Ahora, si esas autoridades logran conseguir la orden de arresto de parte del gobernador de Pensilvania, entonces se la enviarían al gobernador del estado de la Florida, quien revisaría sus documentos y entonces él firmaría una orden de ejecutoria donde entonces se le trasladaría a Pensilvania.
We would then hold a hearing here in Osceola County to determine whether the warrants had been properly issued and whether or not you are the person named in the warrants.
Perdón, si la orden de arresto la firma el gobernador de la Florida, lo que pasaría después, entonces se programaría una audiencia para determinar si esas órdenes de arresto que se han firmado, si se han firmado debidamente y si le aplican a usted, si usted es la persona nombrada en esas órdenes.
We cannot determine your guilt or innocence of on the charge of driving while under the influence. Here in Florida, we can simply determine whether or not they've obtained the proper warrants requiring your return.
Y aquí en la Florida nosotros no podríamos determinar si usted es culpable o inocente de la acusación de haber conducido bajo los efectos, pero lo que sí podemos determinar es que si las órdenes de arresto que han conseguido, que se han ejecutado, firmado, son correctas y debidas para que usted entonces regrese a Pensilvania.
You do have the right to consult with an attorney, and I will at this time appoint the office of the public defender to represent you in this matter.
Y usted tiene el derecho a consultar con un abogado sobre esto, entonces voy a nombrarle a un defensor público para que lo represente en esta causa.
Do you know at this time whether you wish to contest extradition or waive extradition, or do you want to consult with your attorney before making that decision?
¿Sabe usted en este momento si es que usted desea pelear o disputar la extradición de regreso a Pensilvania o si ¿usted está dispuesto a renunciar a ese derecho a pelear esa extradición o si quiere consultar con el defensor público?
No, yo lo que quiero es que me den el release para yo poder ir a arreglar ese caso personalmente en Pensilvania.
Well, what I would like is to be released so that I can go back to Pennsylvania and personally take care of that case over there.
Well, that's not a possibility this morning, but your attorney may be able to explore that. That may be an option for you. So at this time, I'll set the case for a status hearing to allow you, the Public Defender's Office, to consult with you. Let's reset him for status at the IAs on Friday. So a lawyer from the Office of the Public Defender will be talking to you to discuss your options.
Muy bien, eso no es una opción o no es una posibilidad esta mañana, aunque quizás lo pueda hacer después, pero quizás su abogado le podría ayudar con eso. Así que vamos a programar una vista de seguimiento para permitirle una oportunidad para que su abogado de los defensores públicos hable con usted y le explique cuáles son sus opciones.
They will also have the opportunity to speak with the authorities in Pennsylvania to see if an agreement could be reached for a bond to be set or for other conditions of release.
Y además, ese abogado entonces podrá hablar con las autoridades de Pensilvania para ver si pueden llegar a un acuerdo, a ver si se le puede asignar una fianza o si se le pueden imponer algunas otras condiciones sobre su libertad.
Thank you, sir.
Gracias.
Thank you, Mr. Morales.
You're welcome, man. Thank you.
Okay, so that's all we need at this time from the, well, let me see one other thing. Do they happen to have Mr. Gilliard? Kevin Gilliard?
No, Your Honor. That was on no transport.
Okay. All right, well, we're going to switch back and let, I think the rest of your docket will be with Judge Wooten, so they'll be picking him up, picking up the feed.
Okay, thank you.
Thank you, appreciate it.
Yes, sir.
So as to Kevin.
But if it becomes the decision that Judge Blackman's going to be involved in the sentencing, I'm going to consider that to trigger the 10-day window for me to file a motion to disqualify him based on comments he made in the transcript. So again, I'm not posturing, I'm not trying to speak out of turn, but I do want everyone to not be surprised if that did happen later. Because I think that the way that he treated my client during sentencing rises to the level of my client feeling like, as a reasonable person, he could not get a fair resentencing in front of Judge Blackman.
So let's do this. Why don't we just, because some of that you need, obviously need to talk to your client about, potentially if that becomes an issue, Mr. Baird's position might change on having Judge Blackman here. I don't know. So let's just give it a control date to sort out all those issues. Do y'all want me to reach out to Judge Blackman at this point?
No.
Okay. So let's do this. If I set a status for Monday, August 3rd at 9 a.m.
I won't be here. I'm sorry. Can we pick a different date? Just not that week. I could do the next Monday, or I don't know if you're in a trial period or if we need to go. I can go earlier, I guess.
Technically, Monday, August 10th is the beginning of my trial period. I can't imagine any set of circumstances where I'm actually picking a jury. on
Me
August
either.
10th At this point in time. Well, again, I think unless we went back to phase one, actually, I think we'd have to go back to phase one day this week in order for the 30-day window before you bring jurors in to come into effect. So I just don't see how that's going to happen. So how about Monday, August 10th? It doesn't have to be 9 a.m. It could be later in the morning if that's
That sounds great.
Fine by me.
How about Monday, August 10th at 10 a.m.?
Okay.
Now, then the only other question is if we're still in, well, your client won't need to appear at that status, will he?
No, he'll have to be physically present for resentencing.
Obviously.
Court's aware of that, but he's not going anywhere. The court knows, best case scenario, he gets 25 years day for day on the resentencing. So I don't say that lightly or flippantly, but I'm not in a rush to do this in a way where it isn't done right.
Sure.
And I'm going to insist on witnesses being present. So if that means we have to wait till we're allowed to do that, then I would rather wait till we're allowed to do that.
Mr. Baird?
Whatever works for the defense is fine with me.
All right, so here's what we'll do. At this point, we'll just have a status on August 10th at 10. If we are still in phase one on August 10th, since it's just a status hearing, I'm fine doing it virtually so that the lawyers don't have to gear up and come into the courtroom. I'll be in the courtroom so we can make a record,
Okay.
but the lawyers, I'm fine if the lawyers want to do it virtually if we're still in phase one on August 10th.
Are we in phase one now?
We are in phase one.
I wasn't.
Some people would suggest we're in phase 1.5.
Phase 1, 2.0.
It's a moving target. We're doing the best we can under the circumstances. All right. Anything else in regards to Mr. Brown?
No, Your Honor.
Okay, all right.
Thank you.
Have a good day.
You too. Good to see you.
All right, Mr. Ivanor and Ms. LaSure, who is here first and who has the quickest thing?
I hope it's quick, Judge. Jimmy Caceres.
What's he set for?
This is a VOP arraignment. Judge, the state, the only violation is a new law violation. We probably should get the state on.
Okay. Who's the state on this?
Ms. Adams is appearing telephonically.
That was my understanding, Your Honor, that she would be appearing on the phone according to the docket.
Okay. How's your client spell his last name?
I'm sorry, Judge.
How does your client spell his last name?
Caceres.
Okay.
He's present in the courtroom too, Judge.
Okay. Morning, Miss Adams. Can you hear me? Can you please speak up for us? All right, much better. All right, this is State of Florida versus Jimmy Caceres. We are here for a violation of probation arraignment. Ms. LaSure is here in the courtroom. So, Ms. LaSure, what do you want to tell me?
Judge, the only violation was a new law. The state has no billed the new law. The information I got from Ms. Adams was that they were going to request a dismissal of the violation.
Yes, Your Honor, that is correct. So looking at the facts for the new law and the underlying, it does appear that the defendant was confused and was misled by the probation officer regarding the reporting requirements. So it's my position that the violation was not willful. So I'm not the official.
Okay. So, DOC tagged this violation affidavit as a violent felony offender of special concern. State, is it your position that he actually qualifies?
I don't know that he even does. I'm not sure edited it in my head. It was just after news. I'd have to double check that, but I just knew that he would be.
Well, and so it's clear, I don't live and die based on the tagging decision Department of Corrections makes. I mean, they're supposed to tag to make the court aware so the court can evaluate it, but by the same token, if there's not a legal basis to apply that designation, I don't think the department can trump the law by what tag they decide to put on an affidavit. So, Ms. Adams, if your position is that the defendant, as a matter of law, does not qualify as a violent felony offender of special concern, I'm not going to look behind that assessment under the circumstances. And then I think there's no hurdle or impediment to dismissing the violation at the request of the state.
Okay. Yeah, I'm just trying to double check and see if I'm missing something in the statute, but I don't think I am. So it's my position that he's not a violent felony offender of special concern.
Ms. LaSure, what's your position on whether he actually meets the legal
My
definition?
position is, Judge, that I have no position. I will definitely go with the state on that.
Okay. All right, looking at the charge that he pled to, it does not immediately leap out to me that that's a qualifying offense. So, again, there could be a policy over at the Department of Corrections that they tag certain types of cases in every case. Could be a mistake. So, all right. And your position, Ms. Adams, is that you do not believe there's a good faith basis to argue that there's any evidence that would support a finding of a willful violation?
Yes, Your Honor.
All right. Then based on the state's position that the defendant does not qualify as a violent felony offender of special concern and that they believe there's insufficient evidence to support a violation, I will go along with the recommendation and dismiss the violation at this time. How much probation does he have left?
Judge, he has 8 months.
All right. Has he been reporting to his supervising officer while this has been pending?
Yes, although it's difficult to ever get anyone on the phone at probation. He has an appointment with the sheriff's department. He had one today, but because we had to be here, he couldn't be there. So he has one in 5 days. He will report then.
So I'll simply order that he continue to report to a supervising officer as previously directed and continue to comply with the conditions of probation until his term expires or until there's another order from the court.
Thank you, Judge.
All right, anything else, Ms. Adams?
That's all I have. Your Honor.
All right, have a good day. All right, Mr. Ivanor?
Good morning, Your Honor. I have a plea for Mr. Kenneth Phillips. It's in the Osceola County Jail.
Hold on 1 second. Tell me your client's name again.
Kenneth Phillips.
And Phillips. Is this mean, that's what that?
These are, yes, these are all the ones that are on the feed now.
Oh, okay.
And then everybody else in the jail will be here after.
Got it. Okay. Okay, perfect. That makes sense.
Sorry.
No.
I think he may be one that's gonna have to come in the second group.
All right, so, Mr. Ivanor, they've given me a list of the inmates who are currently in the court, the chapel at the jail, and your client does not appear to be on that list. My understanding is if he's not on that list, it means that he's under some type of quarantine provision.
These ones are the.
Oh, I'm sorry, these are the quarantines. So that we have to get all of them done.
No problem.
Send them on their way, and then they will bring in the non-quarantine inmates after that. So I don't know if you have anywhere else that you need to be.
No, I'll wait around.
Okay.
Thank you.
You have a low threshold for entertainment if watching me conduct court is how you're going to spend your free time. All right, so let's go ahead and run through this list of people who are present. I'm guessing that the balance of them are represented by our public defenders?
I have two of them, Your Honor.
Okay. Mr. Smear, what do you have this morning?
I just have one case.
Who is it?
I have Mr. Connor Ani. It's a status hearing.
Kaliko Ani?
Yes, the reason it was set for status hearing was because the original doctor found him to be incompetent. That was Dr. Skaczynski.
Mm-hmm.
So that the state had asked for a second doctor to be appointed, but that doctor was Dr. Tate. There was a lot of things going back and forth. He eventually scheduled a evaluation. Both the prosecutor and myself were pretty wary of the way he was going to do it. Essentially, he wanted to do a three-way where I talked to the client on a Polycom, and Dr. Tate's back in his Hunters Creek office, and then I'm raising on my own phone, my iPhone, and FaceTiming this video screen, Dr. Tate. Neither Ms. Demers or myself found that to be a good practice, so we both agreed that he should probably not be doing examinations.
Okay.
I think Ms. Demers is going to be doing an order suggesting that Dr. Doros do the evaluation, which I have no objection to.
Okay, is that correct?
That's correct, Your Honor. Lauren Demers on behalf of the state. When we were here last, Dr. Tate hadn't completed the eval. We got it set. A lot of technical difficulties, as Mr. Smear explained. Ultimately, the day of the evaluation, we decided to call it based on all of the different moving technological pieces. I did reach out to a few doctors. Dr. Duros seems to be the one most able. I did find it interesting. I talked to Dr. Dorsonville, who said, and I'm just letting the court know this, that she was told by the Ninth Circuit that she wasn't allowed to do evaluations remotely. She'd been doing them through the Polycom system, but then was under some understanding she wasn't allowed to. I tried to run that up through my supervisors, haven't heard back, but Dr. Duros did say that she was good to come in and do it, and according to what these public defenders have told me, in the last week, evaluations have been done. So I think that's just going to be the easiest. Dr. Duros said she could get him scheduled within the next 3 weeks. It would take about a week to get the report, and I would get that order over to everyone. I just finished typing it up so I can actually send it to defense and Madam Clerk for your honor to sign this morning.
Okay. How long do we think it might take Dr. Duros to get an evaluation done under our current circumstances?
I'm very flexible. I mean, we don't have court, obviously, so I'm in the office the entire time. Mr. Ani, who is present, is not going anywhere, so.
She advised about 3 weeks for scheduling, so I would say if we set this off 5 weeks, that should guarantee an extra week buffer, just in case there's any difficulty getting it scheduled this week. I think that would be sufficient time based on what her email represented to me about doing public defender clients in the jail via Polycom.
Mr. Smear, let me ask you this. Between setting it on a Tuesday, when I would anticipate having the jail feed so your client could stand there, and giving it a different day with the understanding that I wouldn't have your client present, but we could potentially do a virtual proceeding, do you want me to calendar this for a Tuesday status hearing or a different day?
Different day would be fine. I'm flexible.
Okay. So here's what we'll do. I'm thinking Monday, August 10th at 9 a.m.
And would Your Honor prefer that I email the order to the clerks in court or to your JA for signing later?
If the clerks don't mind taking it and printing it so I can sign it here, then I'm fine doing that. Mr. Schmier, any objection to that process?
No.
Okay, all right. Anything else we need to do on Mr. Ani's case?
No, Judge. Mr. Ani, did you hear what the court said? Mr. Ani? Yes. Dr. Doros was appointed to see you. I'll give you advance notice, all right? Thank you.
Okay, that's all with Mr. Ani.
Thank you.
All right, so that's it, Mr. Schmier?
Yes.
All right, have a wonderful day.
Sure, thank you.
All right, Ms. Roses, of the people who are, what, is that Mr. McLean I see?
That's him, Judge.
Okay, Mr. McLean.
Good morning to you.
Good morning. I wasn't expecting to see you there.
I know, I came over here, I had to have the client sign the plea form. I don't know if you wanted me to execute, there's a plea agreement that we worked out with the state, and we're ready to resolve the case. I don't know if you want me to come to the courthouse or see if we can do it from here, or it doesn't matter to me. I mean, the state had to sign the plea form, it's stipulated down the department on case number 20, CF 454, 455.
Tell me who your client's name is.
Charlie Brigante.
Okay. Who's the state on Brigante?
Your Honor, Lauren Demers, on behalf of the state, this case originally belonged to Mr. Andrew Bain. He is the one that made the downward departure plea offer. I have reviewed what limited information I have this morning. I'm not quite sure what the basis for the downward departure was, and based on what the defendant scores and his plea history, in his criminal history today, I would not be comfortable signing off on that plea agreement. It is a significant downward departure. It's essentially a credit time served offer, and I'm not comfortable based on the charges that I see and the score sheet that I see to move forward with that plea. And I apologize for not letting defense know sooner. I got that information this morning, but that's my position at this time.
So, Mr. McLean, I don't think that I can compel the prosecutor now standing here in the courtroom to honor a prior prosecutor's agreement under these circumstances. So here's my question. If I reset this to next Tuesday, is that enough time, Mr. McLean, for you to walk through the negotiation history with Ms. Demers and see if she'll get comfortable with the resolution?
I I set this case for proof twice.
Okay.
I drove all the way down here with the understanding that it was going to be a plea. It's been a plea all the way up for the last 2 weeks. It was just the logistics of getting the court to set the case for a plea. And this has been the plea agreement for the last 2 or 3 weeks.
Mr. McLean, I understand your frustration. I don't believe there's any legal basis for me to compel the prosecutor currently in the courtroom to honor what you negotiated with a prior prosecutor. So my only question at this point in time is, and your client's not detrimentally relied. It's not like he's entered a plea and we've shown up for sentencing. And even then, I think the case law says if there's a misunderstanding about the agreement, the correct remedy is let him withdraw his plea, put him back in the posture he was beforehand. So my only question is next Tuesday enough time, or do you think you need more time to negotiate with the current prosecutor?
Well, I don't have my calendar on me, so I can't.
Okay. Here's what we'll do. At this point, I'm simply going to indicate that there is currently not an agreement between the newly assigned prosecutor and the defense. I'll set this case for a pretrial conference on October 6, 2020. If there is a resolution that's agreed between now and then, you can always bring it forward, and we will take care of it then. I'm just not sure what else to do under the circumstances, Mr. McLean. I don't want to bring him back next Tuesday and find out that you've started from square one and there's, a bunch of stuff to do, okay?
Well, my question to the state is there a likelihood that we can resolve it between now and the next week?
In all candor, I'm covering this case today because I'm the one covering the docket. I don't know exactly who is taking over Mr. Bain's docket at this point. I assume we will have some information with that shortly. I can't be certain when, it's not my decision. It is not me that's taking over it permanently. What I can do is send an email over to my supervisor to figure out who temporarily will be handling it, if she wants it to be me. I can try to get that information and have somebody email you. But I don't want to represent anything because what limited information I have it's just that it's very limited. So I don't want to make any promises at this time that the state cannot keep.
All right, under the circumstances, Mr. McLean, again, I empathize with your plight, but I'm not sure there's anything other than set it back for pretrial and trial.
I would prefer you to set it for next Tuesday, let me have an opportunity to reach out to Mr. Bain and whoever the superior are over there.
Well, Mr. Bain probably is not going to answer that question at this point.
Yeah, I know he can't answer the question, but I mean, I would think as the, prior attorney on the case, he could shed some light on why he did what he did. I mean, that might be helpful. I mean,
Here's my only concern, Mr. McLean. Your client's currently considered a quarantine client for the Osceola County Jail. I don't want to automatically set him if, in fact, there's nothing going to happen on this case. So I've given you the new dates. If you, in fact, believe there's a reason to bring him in next Tuesday, you can always contact my judicial assistant and go back on the docket for next Tuesday, okay?
all right,
All right. Sorry about the confusion. Have a good day.
thank you.
All right. All right, Ms. Rosas or Mr. Johnson, of the inmates currently in the courtroom, or Ms. Cobb, who's hiding over there, of the inmates currently in the room, which cases are ready to go?
I have 2 cases.
Okay. Which one do you want to do first?
We can do Lamal Cruz.
Does he need an interpreter?
No, he's
Okay.
on page 6 of the docket.
Looks like he's got 2 cases,
Yes, Your Honor.
a new case and a VOP.
Well, they're both new
okay.
cases,
All right.
but one is a misdemeanor.
Let's have Lamil David Cruz come up.
Maria signed them.
Should you give a score sheet?
I have one.
Let's go ahead and swear him in.
Well, it still needs to be signed.
Yes, ma'am.
Good morning, sir. Tell me your name and your date of birth.
Morning, sir. Domo David Cruz,
Date of birth?
January 2nd of 1999.
Mr. Cruz, you have 2 cases before the court, starting with 19 CF 3985. In that case, you're charged with 4 crimes. Each of them is the crime of petty theft, having 2 prior theft convictions. Each of those is a 3rd-degree felony, each of them punishable up to 5 years in prison. Next, you have case number 20MM899. In that case, you're charged with 6 counts. Each count is a count of violation of pretrial release condition on a domestic violence case. Each of those is a first-degree misdemeanor. Each of those is punishable up to a year in the county jail. Do you understand the crimes you're charged with in these 2 cases?
Yes, sir.
You understand the maximum possible punishment?
Yes, sir.
Ms. Rosas, how does he want to resolve these 2 cases?
Your Honor, as to 19 CF 3985, the state's offer is an adjudication of guilt, 10 months in the Osceola County Jail, followed by 24 months probation, 100 hours of community service, batteries intervention program, drug evaluation and treatment, no hostile contact with the victim, no weapons, and court costs, and that is to run concurrent to 20 MM 899. And as to 20 MM 899, I asked the state attorney what she wanted me to put on that plea form, but I never got a response. I was going to suggest credit time served.
Okay. Mr. Mers, any objection to either credit time served or a concurrent jail sentence on the MM case?
What is his credit time served, Your Honor?
He has 124 days on the felony case and 118 days on the misdemeanor case.
Your Honor, by statute for the misdemeanor, he would be required to complete the batterer's intervention, so I would just ask for the concurrent jail sentence for that 10 months, so that way then he wouldn't have to complete batterer's intervention on the misdemeanor, and we'll just have it on the probation for the felony.
All right. Ms. Rosas, any objection to me structuring the sentence that way?
It's only a 6-day difference, so it's okay.
Okay. Mr. Cruz, is this how you want to resolve your two cases?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
In each of your cases, your attorney has given me a document called a plea form. I'm going to hold them up. The felony case is a 2-page document printed front and back. The misdemeanor case, the form's a 1-page document printed front and back. Did you go over these two documents with the public defender?
Yes, sir.
Did they explain to you all the rights you have and the rights you're giving up in each of these cases when you enter a plea?
Yes, sir.
Did they answer any questions you had about your rights?
Yes, sir.
On the felony, did you initial each paragraph indicating you read and understood what was said in that paragraph?
Yes, sir.
Did you sign the felony plea form?
Yes, sir.
Did you sign the misdemeanor plea form?
sir.
Do you understand you are entering pleas in both of these cases, which means we'll not have a trial in either case, and I will sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter that plea?
No, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive?
No, sir.
Are you satisfied with the work that your public defender has done in handling your two cases?
Yes, sir.
Do you understand, sir, if you are not a citizen of the United States, entry of these pleas would result in your deportation?
Yes, sir.
Mr. Mers, can I have a factual basis for each of the cases? And sir, you can put your mask back up. I'm done talking to you, okay?
Yes, sir.
Yes, Your Honor. As to 2019 CF 3985, at 7-Eleven on at the 7-Eleven on 2655 North John Young Parkway, the defendant on the 11th day of November 2019 took 2 packs of beer without paying and left the store. The defendant later returned approximately an hour and a half later and again took 2 more packs of beer and left without paying. There was a total amount of restitution of $153.94 for that incident. The defendant was then seen back at that 7-Eleven on November 14th, again taking 2 different packs of beer. The approximate value was $49.98 and left the store without paying. A third incident on November 16th, the defendant went to the same store and told the clerk that he was sorry for what he was about to do as he had 2 beer packs in his hand and left the store without paying. Restitution valued at $58.66. The store manager was familiar with the defendant from all of the incidents, was able to identify the defendant as the one who took the beverages and at no point was given permission. The total restitution was approximately $262.58. And the defendant does have prior theft convictions in numerous cases. As it relates to 2020 MM 899, there was an active no contact order between the victim and the defendant under the felony case number 20 CF 779, which was a domestic felony battery. The defendant continued to have contact with the victim while incarcerated, and numerous jail calls between March 19th and March 23rd were listened to and observed the defendant having contact. There are at least 14 calls that were made and contact was made on that case. And all events occurred in Osceola County on both cases.
Ms. Rosas, any objection to the factual basis in either of the 2 cases?
No objection.
All right, so I'm going to accept each of your pleas. I find you're alert and intelligent. Your pleas are freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. Also find a factual basis for the acceptance of each of the pleas in each case. Is there any legal reason why sentence should not now be imposed? Ms. Roses?
No, Your Honor.
All right, so the court having accepted your plea, I'll start with your misdemeanor case. On each of the 6 counts, I'll adjudicate you guilty. On each of the 6 counts, I will sentence you to 10 months. That's 300 days in the Osceola County Jail. I'll give you credit on each of the counts for 118 days time served. I'll order that the sentences on counts 1 through 6 run concurrent with each other and concurrent with the sentence I'm about to announce in your felony case. In case number 19, CF 3985, as to each of the 4 counts, I'll adjudicate you guilty. On each count, I'll sentence you to 10 months in the Osceola County Jail. That's 300 days in the Osceola County Jail. On each of the counts, I'll give you credit for 124 days time served. Each of those counts will be followed by 24 months of supervised probation. As to count 1, I'll order that you report to Department of Corrections probation within 2 working days of your release from custody. I will order that while you're on probation, on count 1, you perform 100 hours of alternative community service at a minimum rate of 8 hours a month. I'll order within 45 days of your release from custody, you enroll in a certified batterers intervention program, and I'll order that you successfully complete the program while you're on probation. I'll also order within 45 days of your release from custody that you get a substance abuse evaluation and comply with any recommended treatment. I will order as a condition of the probation in this case that you have no hostile or violent contact. State, can you actually identify the named victim?
Yes, Your Honor, one moment. Talia Lizette Lopez.
Is it Talia?
Yes.
Thalia.
Order no hostile contact with Talia Lizette Lopez. That means no yelling, no screaming, no pushing, no shoving, no hitting, no threatening, no hostile contact. Order that you possess no weapons or firearms. As to counts 2, 3, and 4, your terms and conditions of probation or comply with all the terms and conditions I announced in count 1. The sentences on counts 1, 2, 3, and 4 on the felony case are concurrent with each other and concurrent with the 6 misdemeanor counts I sentenced you to on 20 MM 899. I'll order that in each case, you pay all statutory required fines, fees, costs, and surcharges. I'll have the clerk announce them by case number, and then I'm going to consolidate the cost, and we'll talk about a payment plan. Madam Clerk, you may announce the cost by case.
Is the restitution being ordered on the phone, please? I know you mentioned the restitution amount.
I'm sorry, was there,
I didn't see it on there, but when she did her part.
right.
That was never part of the negotiation.
I'll simply order restitution reserving as to the amount,
Okay, thank you, Your Honor.
and that's on the felony case.
And 20 MM 899, there's $273 court costs and a $50 public defender lien for a total of $323 in that case. And in 19 CF 3985, there's $418 court cost, a $100 cost of prosecution, and a $100 public defender lien for a total of $618 in that case. The total in both cases together is $941.
That's the combined?
Yes.
All right, sir, if I gave you 90 days from your date of release, is there any reason you can't pay $30 a month towards your cost?
I'll try my best, sir.
All right. I'll order as a condition of your probation within 90 days of your release from custody, you begin making minimum payments at the rate of $30 a month towards your cost till your costs are paid in full. Anything else, Ms. Roses?
Yes, Your Honor. So at the jail, Mr. Cruz's visitation and his jail calls, his jail call privileges have been revoked from him. So he did want me to bring that up to Your Honor, seeing as a part of the negotiation was no hostile contact with the victim, but he can't have contact with the victim or really anybody else right now.
Okay.
So,
Mr. Mers, what's your position? I assume there's a request, and just so we understand, I'm not going to order the jail to do anything, but I'll announce that I have no objection if they decide to make a change. I believe because of the nature of the misdemeanor case, the jail's not letting him have any visitation or contact with the identified victim.
Or anybody, for that matter, so.
So the
I'm sorry,
state's,
Your Honor, so what's the request?
well, I think what he's hoping I'm going to do is that I'm going to order the jail to allow him to have contact. That's not going to happen, but I want to know if you have any objection if I indicate that it's up to the jail to consider that since no hostile contact's been ordered, should they reconsider allowing him to have visitation or contact?
It would be my assumption the jail took that away based on the charges that were filed, so I will just let that be up to the jail.
Okay.
I can't control them either.
All right, so sir, I can't order the jail to enforce or not enforce whatever policies they have. All we'll simply indicate is that the court has no objection if the Osceola County Jail reviews your visitation privileges, and given the fact that I'm allowing no hostile contact with the victim, if they restore some or all of your visitation and phone privileges. But that'll be up to the jail to consider, okay?
Yes, sir, thank you.
All right, you're welcome. Anything else, Mr. Rosas?
No, Your Honor.
That's the judgment and sentence of the court. Defendants remanded to custody of the Osceola County Jail to serve the balance of the sentence. Good luck to you, sir. All right, next, Mr. Rosas.
Next, I have Dexter Roberson. He has 2 cases on page 12.
All right, Dexter Roberson.
And both of those police forms signed, including
Yeah, they were both
Gonzalez's
signed.
case?
No, Maria's was signed, but Cynthia never signed the one that I signed. So do you want us to follow?
Someone needs to, yes.
Let's go ahead and swear Mr. Roberson in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, good morning, sir. Tell me your name and your date of birth.
My name is Dexter Roberson, date of birth, April 12, 1979.
All right, Mr. Roberson, you can put your hand down. Sir, as you stand here, you're charged in 2 cases, starting with 19 CF 3493. In that case, you're charged with 5 crimes. Count 1 is felony battery causing great bodily harm, permanent disability, or permanent disfigurement. Count 2 is resisting an officer with violence. Count 3 is battery on a law enforcement officer. Count 4 is another battery on a law enforcement officer. Those 4 counts are each third-degree felonies, each punishable to 5 years in prison. You also have a violation of pretrial release condition on a domestic violence case, a first-degree misdemeanor, punishable up to a year in the county jail. In 20 CF 1609, you're charged with a single count of battery on a law enforcement officer. Again, that's a third-degree felony, punishable to 5 years in prison. Do you understand the crimes you're charged with in these 2 cases and the maximum possible punishment you're facing?
Yes.
And Ms. Rosas, how does he want to resolve these 2 cases?
Mr. Roberson will be entering pleas of no contest as to both cases. The agreed-upon sentence in 19 CF 3493 is an adjudication of guilt 28.05 months DOC in court costs, and that's to run concurrent to 20 CF 1609. And in 20 CF 1609, it would be an adjudication of guilt, a year and a day DOC, court costs concurrent to 19 CF 3493. And the reason why it's a year and a day on the second case is because he has significantly less jail credit on that case than on the 2019 case. So that's why the state and I structured it that way.
Your Honor, if I could have a moment, because that's not the information that I have from Ms. Gonzalez about the 20 CF 1609 case. I have that to run concurrent for the same amount of DOC time.
Well, the state attorney on the 2020 case is Ms. Morales. So I talked to Ms. Morales about that, and she signed the plea form that had that on there.
So the question I have is then I would be imposing a guideline sentence on one case and a departure sentence on another case, if it's structured that way. A different way, if the intent is basically for him to release at the same time on the 2 cases, another way to approach that is a stipulation as to credit time served on the lower time served case to get it up to the same as the higher time served case. If that's the agreement, I don't have a problem with that, but Ms. Demers is concerned that that's not her understanding of the resolution. So
That's correct, Your Honor. And Ms. Gonzalez is forwarding me an email from Ms. Morales in which everybody agreed that because you're correct, Your Honor, the global score sheet reflects a total bottom of the guideline sentence of 30 months and some change. And then it was my understanding that the agreement, because there was some confusion with the with the single count case, to just make it a global offer for the 2805, which is what he would have scored. And it's my understanding that that was relayed to Ms. Roses. I'm just waiting for Ms. Gonzalez to forward that email over to me.
I think the reason why there's confusion is because Mr. Roberson was also offered a split sentence offer, and he was considering taking that until a couple of days ago. So now he wants to take the just DOC offer, and I think that before Ms. Morales signed the plea form in her case, I think that she read it over, and if she did not agree with the offer that was on the plea form, she would not have signed it.
So, Ms. Roses, as I mentioned earlier today, I think when the court arrives at the entry of a plea and the assigned lawyers are indicating there's a disagreement as to what the agreement was, the appropriate thing for the court to do is not try to compel specific performance. I mean, if the situation was reversed and there was a signed document saying the defendant was going to waive all his time served, and the defendant during the colloquy said, I didn't agree to that, I think everyone would agree that the appropriate thing for the court to do is just stop the plea, reset everyone to where they were before, versus compelling a defendant to proceed with the sentencing where he's indicating he's not actually in agreement. So,
Your Honor, if we could just maybe pass the case, I know there's still a few inmates.
what I was going to suggest is we see if we can't get Ms. Morales to indicate what her actual intent and what her actual agreement was.
I don't know that I'll be able to get Ms. Morales. She is out of the office. But I'm in communication with Ms. Gonzalez, so we're just squaring things away. She's sending me emails, and I assume by the time we get through a few more cases, we'll be able to get this taken care of.
So I'll pass on the case. The challenge is going to be if we finish everything with this group of inmates, I need to empty that corrections needs to empty that chapel and get the next group in. So then we're looking at potentially resetting.
Of course, Your Honor.
I guess my only request is if the state's going to have one attorney handling everybody's cases, they really need to make sure they're up to speed with what the agreements are.
Yes, of
So that
course,
we
Your Honor.
don't keep dragging people into the chapel and exposing them to other potential people that might be infected when we're not actually going to resolve their case. So let's pass on Mr. Roberson to see if we in fact do have an agreement or not. Mr. Roberson, you can sit back down. We'll recall your case when we know what's going on.
Okay, thanks.
You're welcome. Mr. Johnson, what do you have?
Your Honor, first case that I'm covering for this morning is on page 3 of the docket. Anthony Roman, 19 CF 2797. It's here for a VOP arraignment.
Okay. Let's have Anthony Roman come up.
Just for the record, Alex Johnson covering for Donald Carbone.
All right, let's go ahead and swear Mr. Roman in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, good morning, sir. Tell me your name and your date of birth.
Anthony Roman, 1689.
Mr. Roman, you previously were placed on probation for the offense of possession of cocaine. It's now been alleged that you have violated your probation in this matter. Mr. Johnson, the Public Defender's Office is covering for your public defender. What plea does he want to enter at this time?
Be a denial this morning, Your Honor.
I'll enter a denial as to the violation of probation at this point in time.
What is that?
All right, so your public defender is here in the courtroom.
Okay.
They're indicating at this point in time, you're denying that you violated your probation. We'll set you for a status hearing. If you decide later that you want to resolve your violation, then we will resolve it later. Otherwise, we'll figure out when we can have a hearing on your case, okay?
How would I be able to resolve the violation?
Well, the state would need to make an offer. your public defender would need to discuss it with you, and you would need to tell your public defender that that's something that you're willing to accept, okay? So,
Lauren Demers on behalf of the state. It is my understanding that there are still some pending cases to be charged, so there will be a global offer made shortly to defense.
all right, here's what I'll do. Dana or Tabitha, can y'all tell me how many VOP status I've currently set on August 6th, although I think I know? Nice. Good times. All right. Let's go ahead and do this. I'm going to go ahead and open up Thursday, August 13th as a violation of probation status date. And we'll go ahead and put Mr. Roberson's case, or not Mr. Roberson, I'm sorry, Mr. Roman's case on the 13th for VOP status. All right, Mr. Roman, you're currently set for status hearing on August 13th. Your public defender will be talking to you about what the offer is once he gets the offer, okay? All right. Next, Mr. Johnson.
Next case I have is on page 13 of the docket. It's Michael Woods and 20 CF 370. It's a plea date certain this morning.
Okay. Let's go ahead and get Mr. Woods up. Burnham, what do you have this morning? While we're waiting for Mr. Woods.
Nothing else in here at 10 o'clock with the past kid.
Okay. All right. I'll talk to you about that in just a second, Mr. Burnham. All right, let's go ahead and swear Mr. Woods in.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
I do, yes.
All right, good morning, sir. Tell me your name and your date of birth.
Michael Woods, 12/19/1984.
Sir, as you currently stand here, you're charged with 2 crimes. The first is burglary of a dwelling. That's a second-degree felony. It's punishable up to 15 years in prison. Count 2 is criminal mischief with damage of $1,000 or more. A third-degree felony, punishable up to 5 years in prison. Do you understand the nature of the crime you're charged with and the maximum possible punishment?
Yes.
Mr. Johnson, how does he want to resolve this case?
Yes, Your Honor. This morning, Mr. Woods would be entering no contest pleas to, in count 1, he'd be pleading as agreed upon, it would be a burglary of a structure rather than as a dwelling. And count 2 would be pleading no contest to criminal mischief with damage of $1,000 or more. Both of those would be withholds of adjudication. On count 1, you get 36 months of supervised probation. Do a mental health evaluation and follow up with any recommended treatment, comply with medications, no return to the scene, as well as court costs. And count 2 would be a withhold of adjudication, credit time served, and $4,000 of restitution paid as part of count 1 probation.
State, is this your agreement?
Yes, it is, Your Honor.
Mr. Woods, is this how you want to resolve your case?
Yes.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
I haven't been treated for it, but no, I'm not suffering from it.
Okay. Do you read and understand the English language?
Yes.
Your attorney has given me a document called a plea form. It's a 4-page document with your name on it, your case number on it, the charges you're pleading to, the resolution, all your rights. I'm holding it up. Does this document look familiar?
Yes.
Did you go over that with your public defender?
Yes, sir.
They explained to you all the rights you have, the rights you've given up by entering this plea?
Yes.
Did they answer any questions you had about your rights?
Yes, Your Honor.
Did you then go through the document initially in each paragraph and signing on the last page indicating you understood everything?
Yes, sir.
Do you understand you are entering a plea today, which means there will not be a trial in your case, and I will sentence you this morning?
Yes.
Has anyone forced, threatened, or coerced you to enter this plea?
No.
Other than what's been discussed here in open court, has anyone made any other promise to you about the sentence you would receive?
No.
Are you satisfied with the work the public defender's done in handling your case?
Yes, Your Honor.
Do you understand, sir, if you are not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
State factual basis for the 2 counts?
Yes, Your Honor. On or about February 1st, 2020, in Osceola County, Florida, at approximately 10:30, defendant was observed by a witness exiting lot 785. He was confronted by the witness because the house was under construction and the defendant does not work or live there. Defendant turned around and went back inside the home. The witness saw that there was green paint on the walls, windows, and carpet, the same paint that the defendant had with him. The defendant stated he was a worker and worked at the location, but that did not prove to be true. All events occurred in Osceola County, Florida.
No objection from defense?
I'm assuming that the state, if the case went to trial, would prove that there were damages in excess of, I believe, $1,000.
Oh, yep.
Yes, Your Honor, and there is restitution in the amount of $4,000.
All right. All right, sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you. You're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why sentence should not now be imposed, Mr. Johnson?
No, Your Honor.
This appears to be the defendant's first criminal conviction. Is he waiving a PSI?
Yes, Your Honor.
All right, so the court having accepted your plea, I will sentence you as follows. On count one, as to the lesser included offense of burglary of a structure, I will withhold adjudication. I will sentence you to 36 months of supervised probation with the following special conditions. Number one, you spend 158 days in the Osceola County Jail with credit for 158 days time served. I'll order within 45 days, I'll order that you report to Department of Corrections probation within 2 working days of your release from custody. I'll order that while you're on probation, within 45 days of today's date, you obtain a mental health evaluation and comply with any recommended treatment, including taking any prescribed medication in the amounts and dosages as directed by your mental health care provider. I'll order that you not return to the scene of the burglary of the structure. I'll order you pay all statutorily required fines, fees, and costs. On count two, I'll withhold adjudication, sentence you to 158 days in the Osceola County Jail with credit for 158 days time served. I'll order that you pay $4,000 of restitution to the identified victim. Is it my understanding that this payment of restitution is a stipulated condition of the count one probation?
Yes, Your Honor.
Yes, Your Honor.
All right. That'll actually be a condition of your probation on count one. Madam Clerk, can you announce the total cost, including the $4,000 in restitution?
There's $413 court costs, a $100 cost of prosecution, $100 public defender fee. That along with the $4,000 restitution is $4,613.
Sir, I'll order that you pay your cost and restitution as a condition of your probation. I'll order that within 60 days of your release from custody, you begin making payments at a minimum rate of $30 a month towards your costs till your costs are paid in full. Anything else, Mr. Johnson?
Just that there was 2 plea forms. He signed one plea form at the jail. We signed another, but they're both going to be scanned in.
All right. And anything else from the state?
Nothing further, Your Honor.
Anything else, Madam Clerk? That's the judgment and sentence of court. Mr. Woods may be released on this case only. Good luck to you, sir.
Thank you.
So, Mr. Burnham, just quickly, Mr. Burnham. So I have 2 groups of inmates today. I'm currently working with a group of inmates that are quote unquote on quarantine status. I'm almost done with them. When I'm done with them, they're going to take that group away and bring in the new group. Your client, Mr. Kidd, apparently is in the second group. So I'm not exactly sure how many minutes it's going to be before we see Mr. Kidd. And I also have Mr. Ivanor, who's got a plea in the second group. So I want to get him taken care of as quickly as I can, all right? Mr. Johnson, out of our group still here, who, if any, do you have left?
I have Fabian Saez on
Okay.
page 16 of the docket, 19 CF 556. Plead date certain on a violation of probation.
Okay. And I have paperwork.
And this is another case where he signed one form at the jail and we signed one here.
Let's go ahead and swear him in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case to be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, good morning, sir. Tell me your name and your date of birth.
Morning, Fabian Saez, February 13, 1992.
Mr. Saez, you previously were placed on probation for 2 offenses. The first was possession of a controlled substance. The second was DUI, a misdemeanor of the first degree. It's now been alleged that you violated your probation. Do you understand the 2 crimes you were charged with and the allegation of violation?
Yes, sir.
Mr. Johnson, how does he want to resolve his case today?
Yes, Your Honor. This morning, he would enter an admission to the violation of probation as alleged with the understanding from the state that would be an adjudication of guilt, 184 days in the Osceola County Jail with credit for 184 days, and revoke and terminate his probation.
State, is this your agreement?
Yes, it is, Your Honor.
And Mr. Saez, is this how you want to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
I'm not.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
I have been treated, but I'm not suffering.
All right, do you read and understand the English language?
Yes, sir.
All right, can you look up for a second? I'm holding up a document called a violation of probation admission form. Have you gone over one of those?
Yes, sir.
Did you read all of it?
Yes, sir.
Did you have an opportunity to discuss all the rights set out in that form with the public defender?
Yes, sir.
Did they answer any questions about those rights?
Yes.
Did you sign the copy of the form that you were presented with at the Osceola County Jail?
I was not presented with it.
All right. Mr. Johnson, are we going to follow up with that?
Yes, Your Honor, we'll be following, because it was mailed out. There's highlights for him to sign, I guess.
All right, so you've not gotten the form yet?
No, I'm not.
Are you promising me when you get the form, well, actually, it's time served, correct?
Yeah, it is
All right.
time served.
Let me just, hold on.
Okay.
So, did you have a conversation with the public defender where they went over all the rights that you have in this violation proceeding?
Yes, I did.
And did they answer all of your questions you had about your rights?
Yes, sir.
And have you decided it's in your best interest to enter this admission, understanding that I'm going to sentence you this morning?
Yes, sir, I do.
And do you understand that means we're not going to have a hearing in your case? The state's not going to be required to prove that you willfully violated your probation?
Yes, sir.
And you've decided it's in your best interest to resolve this way?
Yes, sir.
Mr. Johnson, you're representing that you went over the entirety of the standard VOP admission form, and the defendant indicated an understanding of all the rights that he was giving up.
Yes, Your Honor, we
All
did
right.
go through line by line, so.
Has anyone forced, threatened, or coerced you to make this admission?
No, sir.
Other than what's been discussed in court, has anyone promised you anything else about the sentence you received?
No, sir.
Are you satisfied with the work the public defender's done in handling your case?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of this admission would result in your deportation?
Yes, I understand.
Now, one other thing to understand, if you had any outstanding conditions on your DUI, it's quite possible, if you've not done those, that your driver's license is going to be revoked until you show proof that you've done them. Do you understand that?
Yes, sir.
So even though I'm revoking and terminating your probation, if you don't finish DUI school or the other things that you were supposed to do, you're never going to get a license back, and that's going to create more problems. You understand that?
Yes, I understand.
All right. And Mr. Johnson, are you conceding that the affidavit of violation sets out a willful basis to believe your client violated his probation?
Yes, Your Honor.
Sir, I'm going to accept your admission. I find you alert, intelligent. Your admission is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the violation based on the affidavit filed in the case. Is there any legal reason why the court should not now impose sentence, Mr. Johnson?
No, Your Honor.
Mr. Saez, the court having accepted your admission, I will adjudicate you guilty. I will sentence you to 184 days in the Osceola County Jail with credit for 182 days time served. I'll revoke and terminate the probation as to each of the 2 counts. I will order that you pay any statutorily required fines, fees, or costs, and any unpaid balance you had on your case. Madam Clerk, what would those be?
There's a $100 cost of prosecution, a $100 public defender lien, and an outstanding balance of $1,025.70 for a total of $1,225.70.
Sir, other than this case, is there anything else that's holding you in custody?
No, sir.
If I gave you 90 days from your date of release, any reason you can't start paying $30 a month towards your cost?
After 90 days, I should have no excuse.
All right. I would agree, but I was giving you a chance to tell me. So I'll order within 90 days of your release from custody, you contact the clerk of the court, set up a payment plan, and make minimum payments of at least $30 a month towards your cost until your costs are paid in full. Anything else, Mr. Johnson?
Just for record's sake, it's just caught. I think the clerks indicate it's 184 days time served.
That's what I'm showing.
Okay, there was just a mishap in the speaking.
You said
180.
184 with credit
All right.
That's why I was just double checking. Yeah, okay.
So it's clear. I'm giving you credit for the 184 days you have actually spent in the Osceola County Jail, so you should be released today. All right?
All right, thank you.
Thank you, Your Honor.
All right. That takes care of Mr. Saez's case. So, of the list I was given, I have a Jose Marrero on a fugitive warrant. Do we
He
still?
was taken, he was a fugitive, sir. He was already taken care of.
Okay. And then that leaves Dexter Roberson. Where do we stand on Mr. Roberson's case?
We also have Mr. Brown.
Mr. Brown is done, so
Okay.
he's good to go. Once I finish Roberson, then you can empty and reset. So where do we stand with Roberson?
Your Honor, I've been in communication with Ms. Gonzalez. It appears that there was some sort of miscommunication between the two ASAs normally assigned to the cases. So I have been asked to just request a reset, and they will get things situated and let Ms. Rosas know.
All right. Ms. Rosas, again, under the circumstances, I understand the frustration, but I don't think that I can do anything other than reset the case. Now, my question is, do you want me to reset it next Tuesday in the hopes that you can iron out the details and get Mr. Roberson's case resolved, or do you need more time? Mr. Roberson will be reset for entry of plea next Tuesday at 9 a.m. All right, so I'm going to give the plea forms back on Roberson. I'm going to send the score sheet back to the state on Roberson. All right, corrections, I'm showing that's everybody on your quote-unquote quarantine list. Is there anybody else I've missed?
No, sir.
All right, how long do you think it's going to take to empty and reload?
Working on it right now, sir.
Okay.
15, 20 minutes.
Your Honor, if I could save them trouble on two clients.
All right, corrections, they're going to save you some trouble if you can listen for a moment.
Yes, sir.
Go ahead.
On Valerie Dixon's case and Shirley Gonzalez Diaz's cases, we were going to be asking to reset both of those defendants. So I don't know if we need to have them brought up since.
All right, did you catch those two names?
I got Dixon.
And Gonzalez Diaz.
Gonzalez Diaz.
Shirley, first name.
Okay.
We don't need those two.
Fantastic.
Okay.
Thank you, sir.
All right. Come up to the microphone.
Can I approach on?
You may. Let's go ahead and swear Mr. Phillips in. Morning.
Raise your right hand, please. Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, good morning, sir. Tell me your name and your date of birth. All right, sir, you have one case before the court today. That's case number 20 CF 079. Do you have a folder for me, Tabitha? Mr. Ivanor, if I understand correctly, the plea form, does he have a 34 count information? Am I?
There's 34 count information. He'll be pleading to counts 13 to 34. There'll be no crossing counts 1 to 12.
All right. So I just want to go over the information with you to make sure you understand all the charges and then the resolution. So you are charged with 34 crimes. Count 1 is scheme to defraud of $20,000 or more. That's a second-degree felony. Count 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12 are each a count of fraudulent use of personal identification. Count of a person 60 years or older. Each of counts 1 through 12 are second-degree felonies. Each of them are punishable by up to 15 years in prison. Counts 13 through 23 are each a count of uttering a forged check. Each of those is a third-degree felony, punishable to 5 years in prison. Counts 24 through 34 are cashing or depositing a worthless item with intent to defraud. Each of those is a third-degree felony, punishable up to 5 years in prison. Do you understand all the crimes you're charged with, sir, and the maximum possible punishment you're facing?
Yes.
Standing here in the courtroom is your attorney, Mr. Ivanor. Mr. Ivanor, how does he want to resolve all of these counts?
Your Honor, at this time, he'll be entering a plea of no contest. Pursuant to plea negotiations, the state agreed to the following. Be adjudicated guilty, sentenced to 5 months in the Osceola County Jail with credit for time served. That'll be followed by 10 years of supervised probation. We agreed to the restitution amount of $19,491.39. He'll be paying $5,000 of that money within 30 days, $5,000 towards restitution. He will not possess any personal identification information of any other person without written notarized consent. There's a cost of investigation of $305.72 to the Osceola County Sheriff's Office, and there's applicable court cost. Again, he'll be pleading to counts 13 to 34, and there'll be no processing, the state will be no processing counts 1 to 12.
All right. And on the issue of restitution, I've been given 3 restitution orders. One is for a victim, Edith Yeagle, but there's no amount.
That's correct, Your Honor.
Then one for the fraud department of J.P. Morgan Chase in the amount of $19,235.
Correct.
And then one to the fraud department of SunTrust Bank in the amount of $256.39.
Correct.
Okay. This is the,
Agreement with everything else that was stated by the defense.
all right, Mr. Phillips, is this how you want to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
No.
Do you read and understand the English language?
Yes, sir.
Your attorney has given me a document called a plea form. I'm going to hold it up. I don't expect you to read it from there, but it's a 4-page document. It's got your name on it, your case number on it, the counts you're pleading to, the resolution, and all of your rights. Did you go over this form with Mr. Ivanor?
Yes, sir.
He explained to you all the rights you have and the rights you're giving up by entering this plea today?
Yes.
Did he answer any questions you had about your rights?
Yes.
Did you then go through the form initially in each paragraph indicating you understood what it explained?
Yes.
Did you then sign on the last page?
Yes.
Do you understand that you are entering a plea today, which means there will not be a trial in your case, and I will sentence you today?
Yes.
Has anyone forced, threatened, or coerced you to enter this plea today?
No.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive?
No, sir.
Now, one thing I want to note, I've been given a criminal punishment code score sheet. It appears that this is going to be something called a departure sentence. Is that correct?
That's correct, Your Honor.
At the appropriate time, we'll let the state make a record on the decision to depart. But Mr. Phillips, do you understand that if you get out and you violate your probation, that the state's not required to continue to do a departure sentence, that you would score prison? Do you understand that?
Yes.
Do you understand if you violated your probation, particularly if it was established that you were engaged in any type of fraudulent activity, you shouldn't assume the court would agree to a departure sentence. You probably should assume that you would be going to prison for a long time. Do you understand that?
Yes.
Have you still decided it's in your best interest to take this deal to close your case?
Yes.
Are you satisfied with the work Mr. Ivanor's done in handling your case?
Yes.
Looks like he got you a real good outcome, sir. Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes.
Mr. Murr's factual basis for counts 13 through 34.
Yes, Your Honor. On or about September 5th, 2018, until approximately October 29th, 2018, the defendant deposited approximately 11 checks from a Chase Bank account ending in 5591, which belonged to the victim Edith Yeagle, into a SunTrust account under the name of Retha Tanis. The checks were deposited by the defendant into the SunTrust account at the branch located at 904 Cypress Parkway in Point Siena, Florida. The fraudulent deposits totaled approximately $24,160. The last deposit for approximately $4,925 was ultimately declined because the bank had already closed the accounts due to fraud. The victim did not authorize the defendant to use her account. Ultimately, it appears that the victim was compensated by the banks, and the restitution is made payable, as we previously discussed, $19,491.39 in total, the $256.39 to SunTrust, and then the remainder for JP Morgan Chase. There's also a cost of investigation in the amount of $305.72. All events occurred in Osceola County, Florida.
Mr. Ivanor, any objection to that factual basis for purposes of these pleas?
No objection.
Sir, I'm going to accept your pleas. I find you alert and intelligent. Your pleas are freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the pleas. Is there any legal reason why sentence should not now be imposed?
Not from the defense, sir.
State anything you want to put on the record in regards to the decision to enter a departure sentence?
Yes, Your Honor. This is Lauren Demers on behalf of the state. I am covering on behalf of Ms. Melinda Merced, our Economic Crimes Unit attorney. I did have permission to move forward with the plea. It does appear that victims have been contacted. There is a significant amount of restitution that is owed. It does appear the victim and witnesses were contacted and approve of this offer to downward depart. And there is a note, and I'm not 100% sure, but it does appear that he may be possibly deported. I'm not sure about that, but it looks like that is a potential possibility as well based on the notes. That's an older note, so I don't know if that was discussed with the defense attorney, but I do see that in Ms. Merced's notes.
Okay. So, Mr. Ivanor, I've asked the standard question on that point, but is there, to your knowledge, is there actual potential for deportation in this case? Is there some activity going
I
on?
believe he has a deportation hold. However, he had his removal case on appeal. I believe he won the appeal. The jurisdiction lies in Miami. I don't know what they're necessarily going to do, and I think he had related cases before out of Miami, and he was able to get out of that deportation. So to be honest, I don't know if it's 100% sure that he's going to get deported.
So, Mr. Phillips, one thing you need to understand, I've already gone over this once, but I'm going to go over it again. If you get out and you report to probation and suddenly the United States government comes in, sweeps you up, puts you in immigration detention, and they ultimately deport you, you can't come back to my court and say, Judge Wooten, I never would have pled. I only pled because I thought I was, for sure I was safe on this immigration issue. You understand that?
Yes, sir.
Okay. All right, the court having accepted your plea, I will sentence you as follows. I will adjudicate you guilty on each of the counts that you pled on. On each count, I'll sentence you to 5 months in the Osceola County Jail with credit for 135 days time served. On each count, that'll be followed by 10 years of supervised probation. Well, Mr. Mers?
Yes.
How am I putting him on 10 years of probation on each count when each count that he pled to is a third-degree felony?
Your Honor, I would ask, in order to effectively do the sentence, we're going to have to run at least 2 counts consecutively. I have no problem running count 1 for 5 years of probation and then 14 through 34 consecutive. I don't know if the court has a preference or defense has a preference of which counts are run consecutive to effectuate the sentence.
Mr. Ivanor, any thoughts?
That was, I think, the agreement that we had with the state. One of the counts would be consecutive, which would give him 10 years of supervised probation.
I just want to make sure we're clear. So the state is telling me that what they want the sentence to reflect is 1 single count will be a consecutive 5-year probationary sentence.
I'm wondering if it's just easier based on how the charges, if counts 13 through 23, since they're all uttering a forged check, is a 5-year sentence, and then counts 24 through 34 is a consecutive 5-year on all of those counts, if that makes sense.
Mr. Ivanor?
I think that makes sense, Your Honor. That was the agreement that we have with Ms. Merced.
Okay,
Yeah, she just didn't specify, but you're exactly correct. We need to do some sort of consecutive sentence there.
called a court reporter, have them print up a transcript. A lawyer said I was absolutely correct. It's like a Dear Diary moment. Mr. Phillips, here's what I'm going to do. On counts 13 through 23, Each of those counts, again, will be 5 months Osceola County Jail, followed by 5 years of supervised probation. Actually, it'll be, let me reword that. It's going to be 5 months Osceola County Jail as a condition of 5 years of supervised probation. The counts 13 through 23, the probationary sentences are going to be concurrent. I'll order that you report to probation within 2 working days of your release from custody. I'll order within 30 days of today's date, you pay $5,000 of restitution. I'll order that the remaining balance of restitution be part of a payment plan that we will discuss in just a moment. I'm going to order restitution in the amount of $19,235 to JP Morgan Chase, the fraud department, $256.39 to the fraud department of SunTrust Bank. I'm going to order cost of investigation in the amount of $305.72 to Osceola County Sheriff's Office. Those, along with all your court costs, are going to be a condition, payments of those are going to be a condition of your probation. On counts 24 through 34, on each count, I'll adjudicate you guilty. I'll sentence you to, on those counts, 135 days in the Osceola County Jail with credit for 135 days time served. Counts 24 through 34 will be, that'll be a condition of 5 years of supervised probation. The terms and conditions of probation on counts 24 through 34 are comply with the terms and conditions I announced on count 13. The sentences on 24 through 34 are consecutive to the sentences in counts 13 through 23, but concurrent with each other. Counts 13 through 23 are concurrent with each other. Madam Clerk, can you announce the total, all the statutorily required fines, fees, and costs, and the restitution amounts?
$418 court cost, the $100 cost of prosecution. That, along with the restitution amounts ordered and the cost of investigation, is $20,315.11.
So, Mr. Phillips, you're agreeing to pay $5,000 of the restitution in the first 30 days. After those 30 days, how much can you pay each month towards your remaining restitution balance? Well, I'm going to set you up on a payment plan. Here's what I'm going to do. I'm going to order that it's $5,000 within 30 days, and then it's $100 a month each and every month after that, until you've paid all your costs, including your restitution, or until you have a further order of the court. So if you can't make that payment, then you need to contact the court and file a motion to have that modified. Do you understand? Okay. Mr. Ivanor, any objection to the manner in which I have announced the sentence?
No, Your Honor, just to clarify, the jail portion would be concurrent on each case. Only the probationary sentence would be consecutive.
Right. What I did on the second series of counts, I just made it time served on those counts, and the probation is consecutive to the sentences I announced. But Madam Clerk, if we can clarify that on counts 24 through 34, the jail portion is concurrent with the counts 13 through 23. The probationary sentences are consecutive to 13 through 23, but concurrent with each other. Mr. Murs, any concerns about the way I've announced the sentence?
No, Your Honor.
Madam Clerk, any questions or concerns about how I've announced the sentence?
The question I have is the restitution being paid equally among all of the counts, or one before the other?
Given the fact that JP Morgan has the lion's share of the restitution, I'll order that the $5,000 be applied to the balance there first. And then they can prorate the balance between JP Morgan and SunTrust going forward. This is a stipulated departure sentence negotiated between the state and the defense. Anything else, Mr. Ivanor?
Nothing further, Your Honor.
Anything else, Mr. Murs? Anything else, Madam Clerk? Did I tell him when to report? Did I tell him when to report? Sir, you need to report to probation within 2 working days of your release from custody.
Yes.
Okay, that's the order of the court. Mr. Ivanor, anything else today?
Nothing further. Thank you, Your Honor.
All right, have a wonderful day.
Oh, and Your Honor, I'll just announce on the record officially, the state at this time will announce a null pros, in this case as to counts 1 through 12, and that will be followed up with the clerk by e-filing as well.
Okay. All right, do we have Cashton Kidd? Come on up, Mr. Burnham. Morning, let's go ahead and swear Mr. Kidd in.
Raise your right hand, please. Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Morning, sir. Tell me your name and your date of birth.
My name is Cashton Kidd, March 5th, 1981.
All right, Mr. Kidd, standing in the courtroom is Mr. Burnham, who I believe is court appointed in this case. Is that correct?
That's correct.
All right. I put you on the docket today, and I actually just need to look your case up real quick. Because if I remember correctly, I got a letter from you, and based on my reading of the letter, it appeared that you were going to ask me to replace Mr. Burnham as your attorney. Did I read your letter correctly?
Yes, Your Honor. As of last week, I filed a civil suit against him, Your Honor. There's definitely a conflict of interest there.
Okay. So, Mr. Burnham, were you aware that the defendant has filed a civil suit against you?
No, I'm not aware of that.
Okay. So, Mr. Kidd, a couple things to discuss at the beginning of this process. Number one, this proceeding's on the record.
Yes, Your Honor.
Number two, the prosecutor on your case has the ability to listen to this entire proceeding. Number three, when you raise this kind of issue, potentially, in order for me to get to the bottom of the issue, I may need to hear answers about discussions you had that normally would be privileged. Normally, what a defendant says to their attorney is privileged. Their attorney can't be compelled to talk about it. But in certain circumstances, when there's a concern like this raised, in order for me to rule, it may become important for me to hear answers that normally would be privileged. Do you understand that?
I understand that, Your Honor.
And you understand that that potentially could give the state a tip as to possible defenses you're exploring or other issues. Do you understand that?
Yes, Your Honor.
And then ultimately, the last thing for you to understand is if I determine that there's not a legal basis to remove your attorney, then you have a decision to make. Do you stay with Mr. Burnham even though you don't care for him to be your lawyer, or do you represent yourself? If that's how you end up deciding to go, that's your decision. There'll be an additional conversation I need to have with you. So have you understood me so far?
Yes, Your Honor.
All right. And let's go back here. I think it was your June
3rd, Your Honor.
June 3rd pleading. All right. So it looks like the clerk of the court actually docketed that on June 9th. So let me just take a minute and look at this again. It was entitled Emergency Habeas Corpus Nelson Hearing, correct?
Yes, Your Honor.
All right. Is everything in that true and correct?
Yes, Your Honor.
Are you swearing it's true and correct?
Yes, Your Honor.
So the issue you raised in that matter was the fact that there was a continuance in the case and that you did not authorize a continuance to be requested and you didn't authorize a waiver of speedy trial, correct?
That's correct, Your Honor.
All right.
I had not ever met with Mr. Burnham, Your Honor.
Okay.
Before 3 p.m. on June 3rd, and court was held at 9 a.m. on June 3rd.
Okay. So, tell me why that decision means that Mr. Burnham is incapable of competently representing you in the case going forward?
Because, Your Honor, when he came to speak with me at around 3 p.m. on June 3rd, I had asked him to look into some matters in my case and file some motions for me. And up until the point of today, he came to see me maybe an hour before court today. And up until that point, I wrote him twice. I tried to make contact with him through my family. Mr. Burnham hasn't made one attempt to file any motions for me. Mr. Burnham hasn't made an attempt to talk to me or anything. He basically swept my case under the rug, Your Honor.
So let me ask you this. What do you think he should have done, or what has he failed to do at this point that you believe he should have done up until this point?
He has failed to give me sufficient counsel. He's failed to appoint me in my case, to represent me in my case.
Well, what specifically did you want him to do that he's failed to do? Let's start there.
Well, first of all, Your Honor, I asked him to come speak with me about my case, and second of all, I did ask him to file a pro se corpus suppression hearing on my own, and from my understanding, according to the court constitution, that habeas corpus is grateful, and so,
Sir, can you get closer to that microphone?
yes, Your Honor. I filed a habeas corpus suppression hearing on pro se, and for some reason it's certain without reason or case law to back it up. But it's supposed to be grateful when the defendant shows back to the that he or she is saying unlawfully, and we shall be grateful by bringing forth the court to carry.
All right, so the short answer, the reason I struck your pro se pleading is you're currently represented by an attorney. When someone's represented by an attorney, they can't file their own pleadings. So
I can't get counsel to do anything that I ask him, Your Honor. Every time I get counsel, it started with the first public defender I had. As soon as I started asking about filing suppression hearings or anything, there was a conflict of interest. And then I had another appointed conflict attorney, Your Honor, and as soon as I asked him to actually do some work in my case, there was a conflict of interest. And now with Mr. Burnham, when I asked him to help me out and do some stuff that I needed that I feel like would be detrimental to my case, he refuses to make contact with me. It's been since June 3rd, Your Honor, and he came an hour before court today to ask me what I wanted. I mean, does that even sound right to you, Your Honor?
well, Mr. Kidd, from experience, one thing I fully appreciate and understand, that the passage of time is dramatically different for someone who's in custody versus someone who's out of custody. And for a defendant accused of a crime, they have very little to do, particularly when they're in custody, other than think about their single case and the issues in their case. And so for them, time drags and everything is slow and they can't wait to address matters. The reality is for attorneys who have numbers of clients, time moves differently. And so you're not the first time I've had somebody tell me, I don't feel like my lawyer's communicating with me. I don't feel like they're responsive in a timely fashion. And so what I have to assess is how realistic that set of requests is, and I have to assess the operating conditions we find ourselves under. Just let me finish, okay? Because I have to give Mr. Burnham a chance to respond as well. As you're probably aware, based on the fact that you have a mask and you're kept in a separate group at the Osceola County Jail, all of our society and our judicial system is struggling with how to deal with the impact of coronavirus and its impact on operations. So I've not had access to a jury since February of this year. I don't know when I'm going to have access to a jury. I've not had access to in-court proceedings except for a small window of about 3 weeks in the month of June. I'm not sure when I'm going to have access to in-court proceedings. So my ability to conduct suppression hearings and violation of probation proceedings and trials has been dramatically curtailed because of the health concern. Attorneys have had their efforts to prepare cases dramatically curtailed because they can't do in-person depositions to work on cases. They have problems going out and speaking with witnesses in order to find out what witnesses might have to say. So these are all challenges. They're not your fault, but they've had an inevitable effect that they've slowed the process by which we handle cases. I'm going to give Mr. Burnham a chance to respond in just a moment, but as far as having a hearing, even if Mr. Burnham had filed motions, I don't know that there would have been any opportunity for those motions to have been heard at this point in time. The issue of speedy trial we can talk about in a moment, but technically the speedy trial rule is currently tolled by the Florida Supreme Court until such time as we can bring juries back in. So again, I don't know when that's going to be. So any other harms to your case that you believe are a product of Mr. Burnham's failure to adequately represent you?
Well, Your Honor, I just want to make one statement. I really can't, like you said, talk about my case because the state is listening, but during my time in here, I've also done my own legal research. I'm a very intelligent person, and I had basically done the work in my case for Mr. Burnham, and I tried to show him that on the 3rd when he came to visit me, and he just kind of ignored me and didn't really, like I said, I understand about COVID-19 and all that, but that's no excuse why he can't make contact with me or reach out to me, Your Honor.
All right.
I mean, my case should not make it to trial, Your Honor.
Okay.
If it would just be presented in a suppression hearing or a hearing, in that matter, if I had sufficient enough legal counsel, it shouldn't take it as far as trial, in my opinion.
Okay, well, Mr. Kidd, I appreciate your diligence. We may end up having a conversation about your ability to do legal research in just a minute. But Mr. Burnham, what is your response to the specific complaint about the waiver of speedy trial and the continuance back on June 3rd, and then the additional complaint that you're not communicating and you're not acting on his request to file a motion to suppress and pursue a motion to suppress?
Yes, sir. I was appointed by Your Honor on the 28th of May, pretrial being set the next week on the 3rd of June. I met with Mr. Kidd. He's incorrect in his recollection. I met with him in the morning before court, at which time he signed a waiver of his appearance at pretrial. I don't think he was being brought anyway. I then came to court, and I told him when I met with him, it was for over a half an hour, that I was just getting the case. I hadn't gotten any discovery. There was no way I could come to court at that time and say I'm ready for trial. He agreed that we were not ready for trial. He suggested he had found some grounds for motions. I said, if you want to file anything, then we're going to need a continuance. We can't file something between pretrial and trial. There are no trials being set. So he understood and agreed that we would move to continue, which necessarily includes a waiver of speedy trial without demand. Of course, he also has, at any point later, the right to demand speedy trial, which is maybe how this thing would end up. So that was clear. I told him that that's what that would require, and he understood it. At least I thought he did. Now, maybe in retrospect, he didn't quite understand, but nevertheless, came to pretrial, having been on the case not quite 6 days, moved for continuance, couldn't get discovery from the state because they'd already provided it to the previous attorneys. The most recent attorney I had was the regional conflict counsel. I don't think they'd gotten it, so I reached out to the public defender. They're linking me up with what they had. The motions he wants to file that was explained to me, I'm not entirely clear on the legal basis of them. I understand he feels he's done some good legal research, but I respectfully present that he's not well-versed in the law or what is subject to being suppressed. But if there is a suppression issue, I'd be happy to pursue it. So at this stage, as of today, I have been appointed to this case for 40 days. That's all. So if there are viable motions that he wants filed, I'd be happy to file them.
Okay. All right. So, Mr. Kidd, in this proceeding, in order for me to remove Mr. Burnham and replace him with another attorney, I have to make a determination that he is failing to provide adequate representation as that is defined in both U.S. Supreme Court case law and Florida case law flowing out of those decisions. The issue of people conflicting off your case, prior attorneys, that's not Mr. Burnham's fault. My understanding is that both the public defender and regional conflict counsel had to conflict off because at some point in the past, they represented somebody else involved in your case. And so ethically, they can't, when they have that prior representation, they ethically can't represent you because they could end up in a situation where something they learned that was privileged about one of the witnesses, they're now in a situation where to defend you, they should use it, except they'd be violating the privilege of that prior attorney. So under the circumstances, I cannot find that Mr. Burnham has failed to provide you adequate representation at this point. So then the question is this. If you're absolutely convinced that you do not want Mr. Burnham to represent you in this matter, then the question is, do you want to represent yourself? And I want to caution you before you answer that question and tell you a couple things. If that's how you want to proceed, I'm actually going to bring you back for another proceeding so I can ask you some additional questions because I want you to think carefully before you ask me to represent yourself. Ultimately, it's your decision. Here's what I am not going to be able to do for you. I'm not going to be able to let you have some kind of hybrid representation where Mr. Burnham stays on the case, but you get to file whatever motions you want to file and conduct whatever proceedings you want to proceed, but he's still there as the lawyer to help you out. If you want the assistance of someone who, Mr. Burnham, I'm not going to embarrass you, but I'm going to estimate someone who has probably safely at least 25 years of experience practicing in the criminal justice system in the state of Florida. If you don't want the benefit of that person on your side and you want to do this on your own, that's your choice. You can ultimately make that choice. The law requires me to ask you certain questions before I do that. And again, before we go down that road, I'm going to want you to sleep on it if that's how you decide to proceed. Or you can stay with Mr. Burnham. And at this point in time, I don't think you've actually suffered any meaningful harm in the litigation of your case. Because even if Mr. Burnham had said, we're not continuing the case, we're not waiving speedy trial, you still would not have gone to trial. You still almost certainly would not have had a hearing on whatever motion you want to file. So I can't find in any way that his representation of you in these circumstances is below the acceptable standard of representation. So I'm going to deny your request to have Mr. Burnham removed and replaced with another attorney. Do you want to come back on another day and discuss whether you want to represent yourself, or do you want to stay with Mr. Burnham at this point and see if you guys can't find a way to work together to defend your case?
For the record, Your Honor, I just wanted to ask the court, what time was the pretrial held on June 3rd in the morning?
I started pretrial on June 3rd, I believe, at 9 a.m.
Then Mr. Burnham just lied on the record in the courtroom because I was in the cell drinking coffee, locked in a 2-man cell at 9 a.m. He, like I said, he didn't come to see me till later in that afternoon, Your Honor. So he just lied on the record.
Okay.
About that. And I also had copies of everything pertaining to my case to give to him that day, and he denied taking them. I had the discovery. I have a way to give him discovery. I had my family make contact with him. He doesn't want to reach out, Your Honor.
All right. So, Mr. Kidd, do you want me to bring you back
Yes, Your Honor.
next Tuesday?
Like I said, I filed a lawsuit against him. He can't represent me. There's a conflict of interest.
Well, Mr. Kidd, you got to be careful about, and just to understand, you certainly can't create your own conflict. So I don't know what the basis of the lawsuit is. If you want me to bring you back on another day so you can sleep on this issue of representing yourself, I'll do that. I may have a form sent out to you at the jail to go over in advance of that. I'm just going to decide whether I want to do it that way or just go over it with you in person in court. But if you want me to bring you back to discuss representing yourself, I'll bring you back next Tuesday and we'll have that discussion.
Yes, because I do not want somebody representing me that doesn't even want to make contact with me.
Okay. So, Mr. Burnham, what I'll anticipate doing is setting a hearing next Tuesday, let's say 11 a.m., to conduct an inquiry as to whether the defendant is going to proceed pro se. So we will address it next
I don't want it to have anything to do with
Tuesday.
my case.
I heard you, Mr. Kidd. No matter what you tell me at this point, the law requires me to ask you a series of questions. I'm required to do it, regardless of whether you don't want to hear the questions. I have to say them. So it'll either take a long time if you keep interrupting me and telling me you don't want Mr. Burnham, or it'll take less time if you listen to the questions I ask and the answers you give me, okay? So I'll bring you back next Tuesday at 11 a.m. on your request to proceed pro se in this matter.
Thank you, Your Honor.
Okay. Mr. Burnham, we'll see you next Tuesday.
Thank you, Your Honor.
All right, have a good day. Ms. Cobb, you had a case on the docket. Mr. Arce, before I recessed, we were in agreement that he would not be transported into the holding cell, given some health concerns.
Yes, sir.
All right, so tell me what the status was.
I filed a motion to determine that he is incompetent to proceed and to commit him to a state hospital.
Okay.
Based on the evaluation by Dr. Skaczynski. I provided the state attorney with a copy of the report, and I have a copy of the report here.
Okay.
Essentially, he was arrested for calling 911, threatening to kill some nurses on Oak Street, and reporting a bomb. He was arrested and subsequently released ROR, and I believe he went to Park Place, where he allegedly committed the same offense and was arrested on several warrants. Now, in case number, Dr. Skaczynski's report, and the state attorney shared with me that she didn't feel like the report laid out the factors for him meeting state hospital. And well, I just want to supplement the report that Dr. Skaczynski met with him, and he didn't get very far because he spat on the doctor. However, the doctor does have prior experience with Mr. Arce. Mr. Arce, when he was at initial appearance, he spat on several of the correctional officers and inmates while at the jail. Now, there is a case.
Well, let me interrupt you for 1 second. So here's the interesting thing. I think ultimately, by law, the decision as to whether someone meets the criteria for commitment to state hospital is a judicial determination. But I think the law does, there has to say that there has to be some basis in evidence to make that finding. I think oftentimes the attorneys default to, well, whatever the mental health expert says, they just go with that. I don't think the case law actually says what the expert's opinion is dispositive. It's a factor to consider. But I've had multiple cases where the mental health experts did not fully understand the factual allegations of the case. And the factual allegations of the case were such that on their face, they supported a determination once that they were incompetent, that they qualified for commitment to the state hospital. So.
Yes, Judge. And in case number 20 CF 1595, he's charged with battery for punching a CO. In case number 20 CF 1579, he is charged with reporting that he will kill all the doctors and the nurses for making a threatening phone call. In case number 2017-17, he is alleged to have hit a person on the bus and to have made a written bomb threat for the bus. And so we have to show by clear and convincing evidence that he is a danger to himself or someone else, or there's a substantial likelihood that he would hurt someone by evidence of past or recent experience or threatening that harm. So I believe that based on the totality of the circumstances, he would meet the requirements to go to state hospital. And I just, the state and I, we want to put that on the record.
Okay.
Because there is only one evaluation.
All right. So, Mr. Mers, do you have any remaining concerns at this point, whether there's a record basis? And we're slightly cart before the horse, because I think I have to receive the report, and there has to be no objection from either side in me considering the report.
May I approach with the report?
You may. Is there any objection to me considering this report?
No, Your Honor.
I'll read it, and then I'll have the clerks file it confidential, since it involves the defendant's mental health status, and I do want it filed in each of the cases.
And Judge, would you take judicial notice of cases for 20 CF 1595, 20 CF 1579, and 2017-17?
I will. All right, for the record, I've reviewed Dr. Skaczynski's report, and I am familiar with the factual allegations in the underlying cases. So just so the record's clear, I'll note that Dr. Skaczynski has noted the defendant has already previously been committed on unrelated cases to the state hospital. That, along with the discipline history at the Osceola County Jail, along with the underlying facts of the new cases before the court, along with the determinations that he is schizophrenic and currently not competent to proceed, I think are sufficient factual basis for the court to conclude the following. Number one, the defendant is currently not competent to proceed. And number two, the defendant poses substantial risk of self-harm or harm to others, and that there's no method of restoration short of commitment to the state hospital that would be appropriate. So, given those determinations, Ms. Cobb, do you have an order that you want me to sign?
Yes, sir.
Now, here's my only question. Do you want to modify the quote-unquote standard order and include or bold or make clear the observations I've made, that I'm considering not only Dr. Skaczynski's report, but the prior hospitalization, if you actually can figure out what case he was previously committed to the state hospital under, and the factual allegations of violent behavior in the various cases. I guess the concern is someone at the state hospital going to read the order and quibble with whether criteria has been met or not. So if that's the concern, I think just bulking the order up to make sure that all the factors I relied on are clearly indicated. My suspicion is if they've seen the defendant before and they've treated him before, then my suspicion is they're going to understand why he's back. So let's do this. How long would it take you to submit an order that specifically identifies the factors I relied on here in court?
I just think it'll take me like
like 15 minutes. I already had a proposed order.
Okay.
So I'll just need to add that, and maybe I can get one of the clerks to print it.
Okay, well, I've got afternoon court, I believe, correct? I'm doing some pleas this afternoon. So I can sign it this afternoon. Okay, all right.
Your Honor, I just want to supplement. I did just ask Ms. Cobb, just because the evaluation was cut short, to supplement the record with her knowledge and obviously the court's knowledge. And I have been brought up to speed on what's been going on with these cases and this defendant. So there is no objection to anything that was relayed, and the state's in agreement.
Okay, all right. The defense to submit an order committing the defendant to state hospital. All right, so who do we have left?
There was also on that case, I know he's not gonna be arraigned, but are they waiving arraignment?
Well,
I know
if he's not competent, I'm not sure I can even arraign him.
Yeah, he can't be arraigned. And Judge, I do want to point out, because I did ask for a number of cases to be set on this docket, but the state hasn't filed on most of those cases. So this is just for case numbers 20 CF 1719, 20 CF 1717, and 20 CF 1579.
Okay.
1595 was filed.
1579.
Right, that was filed, 1595 was filed. And two cases were encompassed.
Okay.
Also into one of them. So everything's set on the docket today. One has been closed because it was.
So let's just take our time, make sure that all of the active cases, when I say active cases, cases that are filed on are on the order. We got time. Like I said, I'm here this afternoon, so I'd rather sign one clean order than get an amended order, next week because something got left off or there was a problem or anything like that. Okay? All right. So what else do we have? I see 2 inmates remaining. Someone tell me who they are? I'm not going to.
We have 4, Your Honor.
Okay.
I have Francisco Claudio Munoz set for a plea.
Okay. Who is the attorney on that? Is that? Is that Mr. Tamarkin's case?
It looks like it, Your Honor.
So here's the only dilemma. Apparently, Mr. Tamarkin thought this was a virtual proceeding. So he's offered to be available by phone. The only issue is I'm not sure whether we can really get the plea done with him over the phone or not. So, Mr. Baird, have you signed plea forms and all those things?
I've never got the plea form to sign, but it looks like in Benchmark, it's been signed and submitted into Benchmark already. So I can give my verbal assent. Well, I'm not even giving assent other than my representation that there's no DNA that I know of that would exonerate the defendant. This is a plea to the bench.
Okay. Let's do this. Can we call Mr. Tamarkin and see if he's available to just see where we stand? Corrections, I'm gonna see if I can't get the defense attorney on the phone.
Yes, sir.
Okay? Okay. So let's get him on the phone, and let's go ahead and get Mr. Claudio Muniz up to the microphone. Am I good?
Yes.
I think I was too slow. Hold on.
Yes.
Mr. Tamarkin, can you hear me? Can you speak up for me?
Hello?
All right, now I can hear you much better. Thank you.
Judge, I apologize. I thought this was video. I had the one with the morning and afternoon confused, and it just happened. I was trading emails with Sharif, and I didn't know whether I should try and run to the courthouse or what I should do.
Right. So here's the wrinkle. I mean, your client's an inmate at the Osceola County Jail. We're on the record. He's up at the microphone at the jail. On in-jail pleas, I typically do those Tuesday morning, but I normally have the lawyers in the courtroom. If it was a negotiated plea where everything was worked out and your client didn't object to you appearing telephonically, I'd be comfortable going forward. But my understanding is the defendant's not actually accepting the state's offer. He's hoping that I'm going to do something better than the state's offer. Is that correct?
Your Honor, we're pleading straight up. He's a juvenile, or at least was at the time of the offense. We are going to be requesting a PDR and a PSI. So the only thing happening today is the plea. We're going to have to make arrangements for whatever we do for me to have his witnesses present for the sentencing.
All right. So under those circumstances, are you comfortable, Mr. Tamarkin, proceeding with the entry of plea today, understanding that we're not going to move into a sentencing hearing today, that I'm going to order a PDR and a PSI?
Yes, sir. That's been my understanding all along.
All right. And Mr. Baird, any argument that it's not appropriate to take the plea this morning, understanding that I'm not proceeding to sentencing this morning?
I have no problem doing the plea this morning, knowing we're not going to sentencing this morning. But another wrinkle is my understanding was the victim was going to be calling in. Obviously, without sentencing today, she wasn't going to be making a victim impact statement today. But I think she wanted to call in to listen to the proceedings, and I'm not sure if she is on the line or how we can get her on the line at this point. You haven't received a phone call?
All right.
Well, she hasn't called in this morning. I believe your JA provided her with a number, so I guess she chose not to call.
So, Mr. Baird, let me ask you then, do you believe that I can proceed at this time and not violate any provisions of the Florida Constitution and the statutes regarding victim notification and victim right to be present at critical stages of the proceeding?
I just want to, real quick, take a look at my emails to see if I have a phone number I can call the victim at.
Well, the dilemma, I guess technically we can get multiple people on the line. So while we're doing this, let's go ahead and swear the defendant in.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, good morning, sir. Tell me your name and your date of birth.
Francisco Claudio Muniz, 122501.
All right, sir, you're out at the Osceola County Jail. Your attorney, Mr. Tamarkin, is appearing telephonically. Are you comfortable proceeding this morning, if I decide to proceed, with your lawyer on the phone as opposed to your lawyer in the courtroom?
Yes, Your Honor.
Okay. So, Mr. Tamarkin, once Mr. Baird makes his representations in regard to the victim, then I'll tell you how we're going to proceed.
That's fine, Judge. And again, I'm 20 minutes away. And
It's, Mr. Tamarkin, it's perfectly understandable, given all the moving parts we have at this point in time. So my needle has not moved at all.
Well, it's understandable, but it's totally my fault. Your JA put in the email where I requested the information and she told me where I was going to be, and I just confused myself. Today's the one to have 4 things going.
Okay.
Which was which. So
All right.
that's how it happened.
Okay. Well, we'll figure out in a couple of minutes what we can get done at this point in time.
Judge, can I have 2 minutes to step into the hall and make a phone call?
Mr. Baird's going to step out, and Mr. Baird, will you advise the victim of the limited nature of today's proceeding to see if that impacts her desire to
I
join?
believe her victim advocate already has.
Okay. All right. Let's ask Dana. Dana. Okay. So, Mr. Tamarkin, I'm being told if the victim's going to want to participate and listen to the entry of the plea, that it's not as simple as just adding her into the call. So my suspicion is we'll probably have to do a reset to next Tuesday and iron out those differences. So
That's fine. Just that's fine, Your Honor. I will. Do a notice. What time is it that you wish it set for?
well, I'm going to wait to see if Mr. Baird indicates that the client.
Oh, I see what you're saying.
Yeah.
Yes, I got you. I jumped.
Right. Now, I've got another prosecutor in here. Mr. Mers, can you just represent the state of Florida for a second? Here's my question, Mr. Tamarkin, and Mr. Mers, if you know the answer. Does anyone know whether PDRs are being conducted right now? And if so, how they're being conducted?
Mine, if I could go forward, because I've got more juvenile cases than he's got going, probably. I think they are being done. I know that everything in juvenile court is being done by phone, but I've had one PDR ordered, and there didn't seem to be an objection by the department.
Okay.
But if we need to continue it out, well, who knows? I can't even begin to fathom what the future looks like.
Right.
So.
It's been a good number of years since I sat in a PDR. My recollection is there were a whole lot of people in that room. So that seems like it wouldn't be the way to do business in our current health environment. So I guess you could get all those people on Zoom or some other way to communicate.
Your Honor, I don't have exact knowledge, right, for how things have been doing while in the pandemic, but I do know from my experience in juvenile previously, I've sat in on PDRs where almost everyone appeared just via phone, even without video conferencing.
Okay.
You know, defense and the client were at one office, and then everyone was in a different place, just based on circumstances and time.
Okay.
So if it's being done, I can imagine it could be done if all parties are willing and agreeable to the virtual and the telephone conference.
Well, that's
Your
good
Honor,
to know.
That's my experience as well, and of course, we will do everything to accommodate the process, but I do have his mother to also get interfaced with the department.
All right. That's what I get for relying on my memory, vague as it might be, of what things used to be like when I had to work for a living. So. All right, well, I'm waiting for Mr. Baird to step back in. Ms. Cobb, what else are you going to have to address when we finish this matter?
I have a bond hearing with Jerry Lee Thompson, and that's with Mr. Baird.
Okay?
But Judge, if I may, could we readdress Mr. Arce?
Sure, well, we're waiting for Mr. Baird to step back in.
Judge, I was told by the mental health professionals at the jail that Mr. Arce, before they go to state hospital, it's required that they get tested for COVID. And Ms. Mendoza, who I was speaking to, she said that she is afraid that he will not cooperate.
Okay.
I spoke to my supervisor, and he said that maybe we can get a court order. Would the court could I have something in the court? Would you like a physical order, or would you like for me just to make an oral pronouncement on the record?
Well, I think before that, you're probably going to need to convince me it's appropriate for me to order the jail to engage in that activity, because it's not a statutory requirement. It's an administrative issue between the Osceola Corrections Department and the state hospital. So I may have authority to sign such an order, but my starting point is I'd like to see the authority to do that. I'm not taking the position that I don't have the authority, but I have always been reluctant to get into these issues of how the jail provides health care, how they, what medications they deliver and what manner they deliver them. So my suspicion is that whoever provides legal counsel to Osceola Corrections probably should be involved in the conversation. And if they think it's appropriate for me to sign an order and somebody can cite some kind of authority for it, then I will certainly review that and consider signing the order.
Thank you.
All right, Mr. Baird has returned. Mr. Baird?
The victim advocate is trying to reach Miss Tommy Osborne. I attempted to call her myself, and my call's not going through.
All right, let's do this. Mr. Tamarkin doesn't object to resetting this to next Tuesday. I'd be
Your
more.
Honor, is there any possible way we could skip a Tuesday? Next Tuesday, I've got Lake County. I just realized that.
All right.
My calendar.
Sure. How about
Okay.
Tuesday, the 21st?
I will send out notice, and what time, again,
Why don't we set this at 10:30 on the 21st? And Mr. Baird, just for your benefit, the clerks are telling me if we're going to have multiple people appearing telephonically, we need to there's a process to set it up as a conference call.
Okay.
I don't know what the mechanics of that are. I'm quite confident that you can sort out with the clerks what needs to be done. And Mr. Tamarkin, I'm anticipating actually seeing you.
Your Honor, I'm putting it in my calendar. I was typing in person.
Okay.
As we spoke, and you'll see me this afternoon too, but
All right.
your video link.
All right, let's go ahead and reset Francisco Claudio Muniz for plea on July 21st at 10:30 a.m.
And, Your Honor, I've got the original of the plea form, obviously. It's in my hands as we speak, because I didn't know if I needed to email it. If it didn't make it through, I will bring that at the appropriate time.
Excellent. I'll see you, on this case, I'll see you on the 21st.
All right, thank you, Judge.
All right, have a good morning. Okay. All right, Mr. Johnson, what do you have left?
Just have two cases, Your Honor. Both cases, the defendants, we didn't bring them over.
Okay.
The first one is Valerie Dixon, 19 CF 2287 on page 7 of the docket.
Right.
In this case, we set it for a status this morning in the hopes that we could talk with Ms. Dixon because she currently has a credit time serve offer. Unfortunately, right now, every communication device that we have set up with the jail for her particular pod is not working.
Okay.
So I can't convey an offer at this time.
Okay.
So I'd be asking if on this case, if we could, at this point, just set it for an upcoming pretrial, and if I can get in touch with her and see if we're gonna plea, if I can.
Do you want to just reset it for next Tuesday and see if we can't get that done?
Yeah, I would prefer that. I was just making sure you didn't want to just keep kicking the can down the road, but.
If the offer's time served, I'd rather bring her in earlier
Yep.
And she might even decide to waive confidentially consulting with you and just take it, and I'll have a longer colloquy with her, and then we'll get her on her way. So let's reset Valerie Dixon for next Tuesday at 9 a.m.
Thank you, Your Honor.
And then next?
Next case, next defendant I had was Sherla Gonzalez Diaz, with multiple cases on page 7, 8, and 9 of the docket. This was set for a plea date certain this morning. However, the state was emailing yesterday with the judicial assistant asking if we could reset. Defense didn't have any objection to resetting because we were trying to sort out. We're going to be stipulating credit time served.
Okay.
This is a sentence that's going to result in DOC time, so
Okay.
it's not like if we did anything today.
All right. Do you want me to set it in 2 weeks on the 21st? Do you think that's enough time?
I think that would be preferred, Your Honor. I believe Ms. Morales is projected to be back in the office on Monday, but just to work out any sort of mechanics, I think 2 weeks would be safer.
All right, so Ms. Gonzalez Diaz's cases are reset for entry of plea on July 21st at 9 a.m.
All right, that's all I have this morning.
Okay.
And just for the court's information, we have 2 interns from the public defender's office in the courtroom this morning.
Good morning, interns. What a wonderful time to try to learn about the practice of law. So you'll have, of course, maybe you'll be teaching us about the practice of law, since everything we rely on and understand is out the window at this point. Welcome aboard. So, all right, let's do this bond hearing, Ms. Cobb. And apparently we've got a couple of arraignments. Let's do the bond hearing, and then we will find out who's left and take care of them. Tell me who your client is on the bond hearing.
Jerry Thompson?
Let's have Jerry Thompson come up.
Benjamin Baird for the state.
You may. Let's go ahead and swear Mr. Thompson in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
Good morning, sir. Tell me your name and your date of birth.
Jerry Thompson, July 4th, 1951.
So, Mr. Thompson, it looks like he's got 2 cases. There's a 19 CF case. He's charged with grand theft in the 3rd degree of a motor vehicle and driving a license revoked as a habitual offender. What's his bond status in that case?
Judge, he has a bond on that case.
He does have a bond?
Well, he picked up he was out on bond, and he picked up a new case.
The 19 CF case?
They're handing me a 19 CF case, 2250.
That case is resolved.
Judge, that case was already resolved.
Okay.
Well, you're on 2 2020 cases, Judge.
Okay. I have one 2020 case, 1492. What's the other case?
20 CF 735.
735. Let's see what that's all about. And what's his bond status in 735?
Judge, one moment. I know he has a bond in it. Oh, I'm sorry. This is the older case.
Mm-hmm.
Where bond was revoked.
Is that because of his arrest on the new law?
Yes, sir.
The new law is 20 CF 1492.
Yes.
All right, so out the gate, question. Are these warrant cases or were these on-view arrest cases?
On view arrest, Your Honor.
Because sometimes we have these situations where there's multiple incidents and a warrant gets issued later for one of the cases, and the alleged conduct in the warrant did not take place while the subject was on bond. But that's not the circumstance here, correct?
No, sir, that's not the circumstance.
Okay. State, is your position going to be that the defendant should remain on a no bond status in 735?
That is correct.
So, Ms. Cobb, what I'd like to do is address that issue first, because obviously if I decide it's not appropriate to release him, then it doesn't matter what amount of money he could post. So, State, other than the facts as alleged in the arrest affidavits, is there any other evidence you want me to consider on the issue of whether should be released or not?
Yes, Your Honor. I've provided to Ms. Cobb a 61-page exhibit that's been marked for identification as Composite Exhibit A. I provided that via email to Ms. Cobb.
Okay, you may.
For the purpose of this hearing, the statement has been marked for identification as Composite Exhibit A, a 61-page exhibit, into evidence as States 1.
Any objection, Ms. Cobb?
No, sir.
All right, it'll be received as States 1 for this proceeding. All right, Mr. Baird, is there a particular portion of the 61 pages that you would want me to focus on?
Your Honor, what's been provided to the court for the first significant portion of that packet are prior bond revocation orders and the accompanying printout of the clerk of court's benchmark system pertaining to that. And I will point the court to what is in my packet as page 3. That's a revocation of bond. I will point the court to page 6. That's a bond revocation. I will point the court to page 9, same thing. I will point the court to page 12, same thing. To page 15, same thing. Page 18, same issue. Page 21, same issue. Page 24, same issue. Page 28, same issue. Page 32, it's the same issue. Page 37, the same issue. And then on page 39, I couldn't get the printout off of benchmark for the actual order, but on page 39, there appears to have been an issue as to whether the defendant failed to appear for a trial. So that's not a bond revocation due to a new law offense while out on bond. That's a failure to appear issue in that one. Continuing on, Your Honor, page 41, I've printed out the defendant's publicly available Corrections Offender Network information from the Florida Department of Corrections. Of particular note here is on page 42, there is an entry for offense date 12/9/1987, where the defendant, according to the DOC record, served 3 years in the Department of Corrections for a prior trafficking in cocaine, a similar charge to the 2 charges that are before the court today, or the 2 cases that are before the court today. That's worth noting that it appears on the DOC records. I have not received an actual rap sheet for this defendant yet, and I have not received J&S's. So that case, that trafficking in cocaine from 1987, I have not been able to find it in the clerk of court system. So it does not appear on the score sheet that I provide to the court. I've also provided the informations for the 2 cases that are before the court today. I provided the arrest affidavits for the 2 cases that are before the court today. Also, the FDLE lab results for the 2 cases that are before the court today. And I've provided the court with a score sheet, again, with the omission of that trafficking in cocaine from 1987 that appears on the DOC records. And finally, I provided the court with 2 copies of the habitual felony offender notice that I have filed in these 2 cases.
So, other than that, any other evidence that you want me to consider, Mr. Baird?
No, Your Honor.
All right. Ms. Cobb, on the issue of whether it's appropriate to release him back into the community on any bond, any evidence you want to offer on that point, or just argument as to the state's evidence on that issue?
This argument as to the state's evidence.
All right, why don't you go ahead and tell me what your argument is to why I should still consider releasing him?
So I'm looking at page 12 of the state's evidence. It looks like my client was out on bond on 17 CF 977 and 17 CF 981. But the new charge that he picked up was subsequently no prost, and that new case is 17 CF 2138. Then we have, it looks like I'm looking at page 24, where my client was on probation, or excuse me, released on case number, looks like 13 CF 4647, and he picked up a new charge, which was 14 CF 398. That case was dismissed, and the other charges were no action. Then I want to go down to looks like he was out on bond and there was a PTR revocation. This is page 37, where he was out on 09 CF 3501 and he picked up a duelist in case number 10 CT 789. And then lastly, my client was, this is page 28, this is a CT case, and he was out on bond on a duelist, and he picks up another duelist. In this case, my client was out on bond on a trafficking case, and the allegation is that this is a new trafficking case. Now, I won't try the case today, but based on the new affidavit, he was in the car with a co-defendant, and the co-defendant had ice or meth in his pockets, and inside of a toolbox that belonged to the co-defendant, there was ice or methamphetamine inside the toolbox. Now, the reason why they are attributing the drugs to my client is because there was also drugs found in the ashtray, which was in arm's length. So it's our position that my client is not guilty of that. So my argument really goes to our bond. I guess the bond schedule is, we want to go for a non-monetary bond. If the court does not believe that a non-monetary bond is appropriate, there are certain factors that the court can do to assure that he will come back to court and assure that he will remain crime-free while out on bond. This isn't the court's first time having Mr. Thompson before the court arguing for a bond hearing. The court knows his ties to the community. But there are other things that the court can do to assure that he remains crime and drug-free while out on bond. One of those is he could be on PTR. He can be drug tested, which was not required of him when the court reduced his bond, I want to say a month ago. He can also be put on GPS monitoring, which was not required of him when the court put him on bond a month ago. Now, I can take testimony as to the fact, but I'm asking that the court, I guess my argument is when he's out on bond, he's not committing violent offenses, and he is staying in the Osceola County community. Based on his age, and I will remind the court about his health condition and it's deteriorating while he's in jail, I'm asking the court to set bond in this matter.
Mr. Baird, I believe I've seen the affidavit for 735. Is the affidavit for 1492 also in here? And if so,
It is, Your Honor.
do you happen to know which page?
It looks like it starts at page 50.
And then the affidavit for 735, which page?
That will be that starts at page 47. Unless I copied the same one in 20s, I don't think I did. No, that's 735 starts at 47.
All right, Ms. Cobb, here are my concerns. Number one, there does appear to be a demonstrated long history of, while the defendant is out on bond, him acquiring at least probable cause to believe new crimes have been committed. That the fact that they ultimately were not pursued, dismissed for some reason, doesn't necessarily address the court's concern about the ability of the defendant to follow court orders while he's out. Now, if the only issue is whether he's going to follow orders or not, I think there's one or two cases that suggest that there may be a point in time where someone's history is so flagrant into the disregard of orders that you can basically hold them. They've demonstrated they're never going to follow orders. Then the analysis becomes, if he's disregarding court orders, is there a concern about safety to the community? You made the observation that he's not been arrested for any violent offenses, which I think the narrow definition of violent, as often used in Florida law, would apply. The question then becomes, is trafficking in controlled substances a behavior that results in a risk to the community? In my experience, it is an offense that results in danger to the community. In my experience, the number one way for someone to be the victim of a homicide in our society is to be in an abusive domestic relationship. But behind that, pretty much the second highest way for somebody to be the victim of a homicide is either be involved in the trafficking of controlled substances or have the misfortune of being close in proximity to people who are trafficking in controlled substances, because there is very often violent activity surrounding that, whether it is attempts to rob the drug traffickers, home invasions, shootouts in parking lots that end up striking innocent children or innocent adults and killing them. And so I do have concerns that the evidence presented is sufficient to convince the court there's at least probable cause to believe that your client's continuing to engage in drug trafficking offenses while out on a drug trafficking offense. I do find that poses a risk to the community, and I'm not convinced that there are any conditions of release I can impose on this defendant that would ensure the court, given this defendant's history, that he would comply with court orders and not engage in any dangerous behavior while he's out on release. So for those reasons, I'm going to deny the request to set bond in case number 20 CF 735. The defendant will remain on a no bond status pending disposition of that case. That's the order of the court in regards to Mr. Thompson. He'll remain in the Osceola County Jail pending disposition of his case. All right. Corrections, do you have any bodies left there that need to talk to
Two
me?
females, Your Honor.
Okay.
I have a Ruth Odell.
Is that an arraignment?
It is.
Okay. Let's call up Ruth Odell. Good afternoon. Let's go ahead and swear her in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Morning, ma'am. Tell me your name and your date of birth. Ma'am, you're currently charged with two crimes. The first is burglary of a dwelling, a second-degree felony, punishable to 15 years in prison, and petty theft, a misdemeanor of the second degree. Has the Office of the Public Defender been appointed to represent her? Do we know?
Yes, Your Honor.
Do you want to enter a plea of not guilty on her behalf at this time?
Yes, Your Honor, I do. However, I filed a motion to transfer in this case. She has a lower case number in Judge Morgan's division. That case number is 20 CF 1178.
Okay. State, are you concurring that there's a lower pending case number?
Yes, Your Honor.
Okay. So here's what we'll do. I'll enter a plea of not guilty on your behalf. I'll grant the motion to transfer the case to Judge Morgan's division. Do we happen to have,
Her other case is set for pretrial, August 11th, trial period beginning August 24th. That is, with RCC, so it would be August 12th pretrial.
Ms. Cobb, you want me to put on the August 12th pretrial?
Yes, Your Honor.
All right, ma'am, I'll set you for pretrial in front of Judge Morgan on August 12th with a trial period that starts thereafter.
Okay.
All right,
Thank you.
you're welcome. And then who's our last subject?
The Shelley Paul.
Shelley Ball. Let's have her come up.
Paul, sir.
Paul, I'm sorry.
That's all right.
Good afternoon, ma'am. Let's go ahead and swear her in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, good afternoon, ma'am. Tell me your name and your date of birth.
Shelley Paul, May 26, 1985.
Ma'am, you're currently charged with one crime. It's the crime of petty theft, having 2 or more prior theft convictions, a third-degree felony, punishment of 5 years in prison. Has the Office of the Public Defender been appointed to represent Ms. Paul?
One moment, sir. May I have the case number, please?
20 CF 1582.
You were, the PD's office was appointed at IAA. Okay.
Do we know if the defendant's ever filled out an affidavit?
They haven't, I know, right now with them in jail, we usually have just been putting public defender on names unless they're out.
Ms. Paul, let me ask you this. Do you have any money in a checking or savings account?
I'm in the process of getting my social security card on.
Okay. Are they going to give it to you while you're in custody?
No,
Okay. And do you own a home or other property that you could sell or put a lien on in order to pay for a lawyer?
no,
Do you have any money in a savings account that you could use to hire a lawyer?
no,
Do you own a car that you could take a loan against in order to
No.
hire a lawyer?
no,
And do you receive some form of disability?
not at the moment. I'm in the process of appeal.
All right, so have you ever actually gotten any disability from the Social Security?
Yes, I have.
What was the amount you would get?
724.
All right. Then I'm going to find, based on your answers, that you qualify for the services of the public defender. I'll formally appoint the Office of the Public Defender to represent you. Ms. Cobb, do you know how long it's going to take to open the case in your system and get somebody assigned?
1 day.
All right. I'll enter a plea of not guilty on your behalf. I'm going to set you for a pretrial conference of October 7th, 2020, with a trial period currently scheduled to start October 19th, 2020. Ma'am, you should hear from someone from the Public Defender's Office, I suspect, next week. If you don't, then reach out to them and follow up, all right?
Yes, sir.
Anything else I need to do on Ms. Paul's case? All right, that's the order of the court in regards to Ms. Paul. All right, state or defense, do you think there are any other cases we should be addressing that have not been addressed?
Those are the last ones I had, Your Honor.
That's all that I've had, although I am notorious for leaving one off.
I just figured it's because you're looking for excuses to come back and see me. Corrections, have you run out of inmates?
That's it, sir.
You don't want to round anybody up in the hall, bring them in and let them talk to me?
No, I don't think so, sir.
All right, why don't we all go get lunch then? That sounds like a good plan.
Thank you.
All right, have a good day.
You too, sir.
All right, we're in recess until 1:15. So.
PTR, I completed
That's how I ended up getting a part-time job through Habitat for Humanity. I did all my hours, I completed the whole entire program.
Okay.
They had given me the paperwork. I ended up moving. I lost the paperwork, but I'm sure it should be in the computer, but I completed, and now I got in a car crash yesterday, and I was at the hospital, you know, and the officers were standing by the door,
Yes, sir.
and they're like, we have a warrant. Like, she didn't say until, like, they cleared me to go, and she's like, basically, I'm not trying to babble on. It's just,
All right,
this
well,
needs to be taken care of.
Mr. Bolter, that may be the case. There's nothing I can do about that this afternoon. An attorney from the Office of the Public Defender will be in touch with you shortly. That's very important for that attorney to know, because if you've satisfied the requirements of pretrial diversion, it may be able to close the case out, but I can't tell you that today. So at this time, I've appointed counsel to represent you. Right now, your bond remains at $2,000. That may be subject to change. All right? Thank you, sir. Hubert Edmond. You wish to waive the reading of the charges?
Yes, Your Honor.
State your name, please.
Hubert Lee Edmond Jr.
Mr. Edmond, you arrested on warrant charging with 2 counts. Are you aware of what the charges are, sir?
The charges are about not having a sticker on my driver license or something.
Okay. So you are aware of what you were arrested for?
Yeah, he just explained it to me
Okay.
yesterday.
Do you have any prior history other than,
Yes, Judge, going back to 1996, charge of robbery, which is found guilty. Most recently, 2001 violation of probation, history out of Georgia and South Carolina, charges of possession of firearms, fugitive from justice one time in South Carolina, failure to appear, so that is all.
all right, Mr. Edmond, I'm going to set the bond in the amount of $1,000 for count 1, $150 for count 2, so you can post bond, be released pending your next court date. The Public Defender's Office is appointed to represent you at this time. Your next court date will be on demand in circuit court, sir. Thank you. Sorry? $1,000 for count 1, $150 for count 2. DeAndre Holmes?
Any approved?
Afternoon, Mr. Holmes. State your name, please.
DeAndre Holmes.
Mr. Holmes, you're arrested on a warrant for aggravated assault. Your bond was set at 0. Do you have any prior history on Mr. Holmes?
Has history from 2005, failure to appear 3 times. Most recently, fleeing and eluding a law enforcement officer with lights in 2015. Domestic battery in 2018. Aggravated assault with intent to commit a felony. 2019, no info. Has an active warrant out of Georgia for a violation of probation and a dwellers. There's no extradition on that.
All right. So did you indicate there was or was not a prior felony conviction?
I'm sorry, Judge?
All right. Is there a prior felony conviction in that record? I didn't.
A felony conviction, the fleeing and eluding in 2015, fleeing and eluding Leo with lights, and kidnapping, false imprisonment.
All right, Mr. Holmes, I'm going to set bond on this charge in the amount of $2,500. If you do post bond, it will be conditioned of your release that you not have contact directly or indirectly with Deja Sanchez Horace. You will not possess any weapons or firearms as a condition of your bond. The Public Defender's Office is appointed. Your next court date will be on demand in circuit court.
Sorry, Your Honor, the state would also request order to not return to the scene.
Well, the scene was the side of the road, I think.
Oh, I'm sorry.
Yeah.
I believe I had this confused with a different case.
Okay.
My apologies.
That's all right. Thank you, sir. Gabriel Irizarry Quadrado. What is your name, sir?
Gabriel Irizarry Cuadrado.
Mr. Irizarry Quadrado, you arrested on a warrant on charges of theft of a credit card or unauthorized possession of a credit card and fraudulent use of a credit card. Your bond is $1,500 on the first charge and $500 on the second charge, so you have a total bond of $2,000. The public defender's office is appointed in your case. Your next court date will be on demand in circuit court, sir. Thank you. James Blake.
Good afternoon.
Good afternoon. State your name, please.
James Cohen Blake.
Mr. Blake, you're arrested on charges of felony battery and possession of a weapon by a convicted felon. The bond was set at $1,000 on the felony battery and $4,000 on the possession of the weapon charge. Given the nature of the weapon, I'm going to reduce the bond on that charge to $1,000, so your total bond is $2,000. The public defender's office has been appointed to represent you. Your next court date will be on demand in circuit court. Your bond will be conditioned upon you not having contact directly or indirectly with David Earl Albritton. All right, thank you.
Thank you, sir.
Your Honor, if I may, Elinette Perez on behalf of the Public Defender's Office. In review of the charging affidavit, as far as the possession of the weapon, the report states that it was Jose that was in possession of the knife,
That's
and not
actually
James.
the allegation, and that's why I reduced the bond. The allegation was that Mr. Blake possessed a bat.
The bat?
The way he used it
Okay.
would constitute a weapon.
Thank you, Your Honor.
Warren Cooney.
PD approved. Your Honor, the defense waives the reading of the charges.
State your name, please. What is your name, sir?
Yeah, my name is Warren Cooney.
All right, Mr. Cooney, you were arrested. You understand what the charge is that you were arrested for? The public defender's office waived the reading of the charge itself, but do you understand what it is you were arrested for?
Yes, sir, I do understand.
Okay. Your bond was set at $0. Any prior history on Mr. Cooney?
The defendant has no local history, has history out of New Jersey, 1988, simple assault charge, and 1989, possession of cocaine. And we weren't able to contact the victim.
All right. Mr. Cooney, I'm going to set bond in your case the amount of $500.
For how much, sir?
$500.
Okay.
That will be conditioned upon supervision by pretrial release if you do post that bond. It will be a condition of your bond and pretrial release that until further order of the court, you not return to the residence at 2875 Middleton Circle. You may do so on one occasion accompanied by a law enforcement officer to pick up any clothing or personal possessions you may need from that residence.
Okay.
It will also be a condition that until further order of the court, you not have contact directly or indirectly with Dorothy Cooney. You will not possess or consume any alcoholic beverages or any controlled substance without a valid prescription. You will be subject to testing to ensure that you comply with that. You will not possess any weapons or firearms. Ms. Cooney, the conditions may be modified by the judge that will be handling your case. If you want to return or you want to have contact, that may be possible in the future. Talk to your attorney about that. He or she can schedule a hearing before the court that will be handling your case. But until or unless that condition is modified, it is absolutely critical that you not have contact with Ms. Cooney or return to the residence except with the law enforcement officer.
Okay.
If you do either of those, even if she invites you to come back, if you do that without the order being modified, you could wind up sitting in jail without any bond until your case is resolved.
Okay, thank you, sir.
All right, if you post bond, I would suggest you contact the office of the public defender immediately. If you are unable to post bond, a lawyer from that office will be in touch with you. Your next court dates will be,
Next court date is still in jail, July 16th, IFA, August 14th, in courtroom 4E at 9:30 a.m.
okay, those dates and times, the Office of Pretrial Release will have, and you'll have a written copy of those before you get out of jail. You understand? You look confused.
I'm sorry, sir, I'm hard of hearing.
Okay. The clerk has announced your next court dates. There's a court date that is scheduled if you are unable to get out of jail, and that is July 16th at jail arraignments. If you do post bond and are released, your next court date will be August 14th. The pretrial release office will have that information. They will interview you before you are released if you do post bond. So they'll give you that information. You'll have the court dates on paper.
Okay, so what you're saying, if bond's not posted, I'll have a court date July 16th?
July 16th.
Okay,
Correct.
I heard you, sir, I'm hard of hearing.
Very well, no problem. Did you hear everything else? You have all the information you need?
I heard much everything, I'm pretty sure.
Okay, fair enough. Thank you, sir.
All right, thank you.
Thank you. Freddie Melendez.
PD approved.
All right, good afternoon. State your name, sir.
My name is Freddie Melendez, and good afternoon.
Mr. Melendez, you arrested on charge of battering a law enforcement officer, resisting an officer without violence, 2 counts of battery, and 1 count of attempt to commit murder. The court found probable cause, or this court finds probable cause as to the first 4 charges. The state had additional chance to present additional evidence as to the attempted murder charge.
And Your Honor, regarding that reset, I do have 2 supplemental reports. They were turned over to defense. I would like to present the court with these reports now.
All right. Thank you. Well, it's arguable, but I'm going to find no probable cause on the attempted murder charge. So as to that count, you'll be released on your recognizance. Your bond is $1,000 on the battering a law enforcement officer, $1,000 on resisting an arrest without violence, $500 on each of the battery charges.
And Your Honor, regarding not finding probable cause for the attempted murder, the state would ask that probable cause be fined for a lesser included of battery by strangulation. Would be so inclined to find.
Well, there is evidence sufficient to establish battery by strangulation, certainly. So as to that count, I'll set bond the amount of $2,000. Mr. Melendez, your bonds will be conditioned upon you not having contact directly or indirectly with Jose R. Melendez or with Elizabeth Melendez or with any of the witnesses whose names were mentioned in the arrest affidavit. It will be further conditioned upon you not possessing or consuming any alcoholic beverages or any controlled substance without a valid prescription. The Public Defender's Office has been appointed to represent you in this case. Your next court date will be on demand in circuit court, sir. Thank you. believe that's all.
Your Honor, it'll just be just a few minutes for the last two.
Okay, thank you. Okay.
Okay, Your Honor, we have them.
All right, thank you. Paradise Bellamy. Afternoon, state your name, please.
Paradise Inez Bellamy.
Ms. Bellamy, you arrested on a warrant out of Orange County for a violation of probation on a charge of robbery by sudden snatching. Your bond was set at $0. The public defender's office is appointed, actually, you're represented by Mr. Mandel. Okay, does he know you're in custody?
That was for my last
Your last, when the case first came up?
no, when I was in 33rd.
I'm sorry?
When I was in 33rd Orange County.
Right.
He was my private attorney for that.
Okay, are you hiring him to represent you on the violation of probation, or do you know?
I'm going to hire a new one. I have a public defender right now, and then I'm going to hire. I'm waiting. on
Okay, well, while you're in the Osceola County Jail, until or unless you make arrangements to hire a lawyer, I'm going to appoint the Office of the Public Defender to represent you. They will be in touch with you shortly. You're going to remain held at no bond at this time. You can talk to your public defender about the possibility of getting that bond adjusted, or even possibly resolving the case while you're here in the Osceola County Jail, since they aren't presently transporting between the jails.
Yes.
Okay, so someone from the Office of the Public Defender will be in touch with you.
I have a public defender, Alicia or something.
Alicia Smith?
Yes. I just talked to her today.
Okay, well, that was not on this case, since this is an Orange County case, but her office is appointed. It may or may not be her that represents you in this matter. Okay? Thank you.
Thank you.
Anna Veloz.
Your Honor,
All right, good afternoon. State your name, please.
Anna Veloz.
Ms. Veloz, you're arrested on a charge of battery. Your bond is presently set at 0. There's apparently a witness here who wants to provide some input to the court, so we'll be at ease for a moment while we wait for that witness to arrive. While we're doing that, do we have any prior criminal history?
Yes, Judge, she has, the defendant has history going back to 2006, charges of grand theft, petty theft. Has an open case which is out on bond for Polk County for a driver license suspended with knowledge, second conviction, and a failure to appear subsequently. And that's all.
Sir, if you'll raise your right hand, you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? What is your name, sir?
Wilfredo Basara.
Okay, Mr. Basara, you are named as the alleged victim in a case involving Ms. Veloz, and the court is considering setting bond or conditions of release. I'm interested in input you may have in that regard. Let me first ask you, are you in fear of Ms. Veloz?
Not at all.
Do you wish to have contact with her?
Of course.
If she were released and had contact with you, if something like this happened in the future, would you hesitate to contact law enforcement?
Not at all.
Any questions from the state?
No, Your Honor.
Okay. All right, and let me ask this further. Had Ms. Veloz been drinking at the time this occurred? Okay. All right.
Can I explain a little something?
No, that's not necessary at this stage. Now, I've appointed the Office of the Public Defender to represent her. You may want to talk to one of the attorneys from that office. The state attorney is also here. As the victim, the state would be interested in input you may have with respect to whether or not to file charges. You can contact that office and they'll
I'm not found.
link you with a victim advocate who can get that information from you. But I don't have any further questions of you at this time. All right, thank you.
Thank you.
Ms. Veloz, based on the nature of the charge, you cannot be released and you do not qualify for pretrial release. But I will set bond in your case in the amount of $250. You'll be conditioned upon you having no hostile contact with Wilfredo Basara. That means no pushing, no shoving, no biting, no scratching. If you two can't get along, you need to just separate yourself to avoid a violation of your bond conditions. I won't impose any other restrictions on you. The Public Defender's Office is appointed to represent you. Your next court date will be?
Next court date, if still in jail, July 16th. If out, August 3rd, in courtroom 4A at 1 p.m.
And of course, taking no action on the Polk County case. All right, thank you. All right, I believe that's all we have. We had a couple, well, you all were here, I think, when we had folks who were in the hospital, we announced.
Is it the Woods? They bonded prior, okay. Thank you.
Have a good afternoon. Thank you, folks.
Yes, sir, thank you.